George has said a number of the things that I would like to say. I affirm what he says. I've known or knew Ronald Dworkin for a very long time indeed. I first met him in 1973. I went to Oxford expecting to have Herbert Hart as my supervisor. I was terribly disappointed to discover he'd just become principal at Brasenose College, and I got a letter from the board of the Oxford faculty saying that my supervisor was a man called Mr. Dworkin. I always remember that, Mr. Dworkin. I was terribly disappointed because up to that point I was a positivist. What impressed me about Hart was the emphasis on clarity and making the law certain, and the ability which his theory gave you, I thought, to be able to identify law independently of moral judgment. I thought that was its virtue. And I met Dworkin in a classroom before I met him personally, and I was always struck by the first words that he met. He says to a crowd of unbelievers, because there were unbelievers in the audience in those days, well, as you know, and I didn't know, as you know, I believe in natural legal rights. And it just stuck me and stuck in my head ever since. George has said what he was like. I'd add one or two things about him for your interest that particularly attracted me to him. One thing I would say is that he had the most incredible ability to move from, I've never seen it in anybody else, from the very abstract, the most abstract, right down to the very nitty-gritty, right down to the facts on the earth, the most concrete of examples, and he could swing between the two without any problem at all. And so there was always a problem with an audience that he had, there would be philosophers there who could deal with the most abstract, and there'd be lawyers there who could deal with the most minute practical problems, but neither group could do the two things, and they'd be rather sceptical. Now, I was attracted to Dworkin. I just jotted these down this morning. The first thing was when he said so many years ago that principles were an important part of legal reasoning. You shouldn't think of a set of rules constituting the whole domain of law. You should include principles as well. And he there, I think, started talking, or started his idea about the importance of evaluative value reasoning in law. And as you can see, that cuts into the idea of the crystal clarity which I originally found attractive in Hart. Law involved controversial evaluative application of principles which were defined by a matter of weight. They didn't apply, as he famously said, in an all or nothing fashion. And he, shortly after that, talked about the inappropriateness of judges applying matters of policy. He thought these were matters that had to be settled in a properly functioning democracy by the legislature. Judges were concerned with rights, not goals. Principles, he thought, were political statements about rights. Policies were political statements about goals. And that was the introduction, through the idea of evaluation, to the anti-utilitarian strain of his work. In other words, introduction to the idea of moral rights as part of legal argument. This was all quite revolutionary, and people reacted against it, and I did it first. I had a miserable first term, bringing essays to him, telling him why he was wrong, and I'd walk away rebuffed each time, and eventually I couldn't produce the arguments, because time and again when you looked at legal cases you could see that they were about matters of evaluation, not matters of just the mere application of rules. Secondly, I found his analogy with art very attractive. The idea of interpretations spreading not just through the domain of law, but the domain of art as well. I thought, since lawyers talk about interpretation, it's absolutely common for a barrister to interpret cases, law students do it, judges do it, but also something must be brought out about the idea of interpretation of works of art and music, literature, and so on. And I thought that this was important. And I thought point 1 about principles and point 2 about art meant that law to me became much more important. It was, under the conception I'd been operating, and obviously George as well, was boring. That this made law a subject of the humanities, connected it with art, connected it with evaluative reasoning. And that was when I was hooked. The two other, the third and the fourth points that attracted me to Dworkin was that he thought of law as an argumentative attitude, that law was about argument. If you've been in a barrister's office, as many as you will have been, it's just about argument. When I was a barrister, the door would open often and a head would pop round in barristers' chambers and say, have you got an argument? I've got to appear in front of Donaldson in 2 hours and I need an argument. And they'd tell you the rough facts, they'd tell you the statute and so on, and you have to help them and think. But this is so different from the idea of a model of rules. It's not just plucking rules out of conceptual warehouses, it's actually getting involved in the argument itself. Law is not a set of rules to be applied algorithmically. And then finally, attention to cases. Dworkin was great on cases. And I mean, if you've read my paper, you'll see I asked the question of the 10 most well-known books on legal philosophy that have been published by the world's best presses. How many cases are mentioned in those 10 books? I'd say no more than 4 or 5 cases. And Dworkin was absolutely against this. He thought that you had to do legal philosophy from the inside out. You start off with the cases and then you move out and work away at them and then get to a higher and higher level. You don't stop at a Sunsteinian or Senian level. You go right to the very most abstract concepts that are driving, or the most abstract evaluative propositions that drive the work on the ground. And this is extremely important, and it's why he thinks philosophy is a driving engine for law, but in fact he sees it round the other way. You start off with the actual practical cases, and so many times I would see him in a seminar, someone would put a point to him and he'd say, well, give us a case. Tell us what the circumstances are which I can make a comment on. And there I completely agree with the final paragraph of George, all the rest of it as well, but the final paragraph of George's paper. He says, well, maybe we should start with the moral right, because certainly my observation of barristers is that they will go to a hard case, which barristers are only concerned with, of course, the controversial cases. They'll go to the case and they will intuit, I don't know what the right word is, what right their client has, they believe their client has, and then they'll work out from that. And this to me was all very attractive about Dworkin, and I knew him for 41 years, and in a way a lot of my career, if that's the right way to describe a university job, has been bound up with Dworkin, partly because I think what he said is so important. Partly it's because I find many times, so many times, it becomes frustrating that people don't read carefully enough what he says. They don't grasp really quite what he's about, and so many mistakes are made in understanding him, and that's why this paper is directed at what I think is the most common fundamental mistake that people will make about Ronald Dworkin. And they're mixed. There are two components to it. One is that they don't understand that he is saying law is about value. It's evaluative reasoning. And secondly, that there are right answers to evaluative questions, even though we can't show for certain or prove or demonstrate what they are. And that one right answer thesis is what so many people have found impossible to understand about Dworkin. And I believe it's the reason why he is described as, or his philosophy is described as arrogant. Oh, they are only Dworkin's right answers. They're right for him, but why should they be right for other people? The whole thing is subjective. So let me concentrate on the idea of objectivity. The very early arguments were they came from positivists, and most of them were in America, but there was a Scottish contingent as well, led by Neil McCormick. If in a hard case, a controversial case, where a judge is faced with a number of possible answers, since you couldn't prove what the right answer was, since you couldn't show what it was, then there was no right answer there. So if there's no right answer in these areas which principles are supposed to govern, then this proves that positivism is right, because either answer that the judge comes to, and there are only two, either for the defendant or against the defendant, each of them hasn't got a truth value. So it's pure discretion. All right. I won't say any more about that argument. It begs the question in my view, but the arguments are subsumed in the comments I make about objectivity. Right. First point to make is that about objectivity is we all argue like this, of course. We all act in our ordinary lives as though we believed that there was one right answer on all questions of morality, about art and so on. It's I believe, a true sociological fact. It's only a sociological fact, but I think it's true, and I think it's embedded in the language that we use. It doesn't seem to move terribly many jurists, this point, but it's a point that Dworkin often makes. He says, when you get into the area of theory, people go mad. They start saying that there's no objectivity to moral propositions or value propositions and so on. And then they'll go home and they'll treat their kids properly. They refrain from murdering on the way to the office or within the office itself. And they become quite refined about it, and they don't just assert moral propositions. They argue them. They say, you're wrong to think that about abortion. Abortion's permissible because the fetus is not sentient. So there's something different at stake here. They'll say that kind of thing. Or they'll say, well, you can't say homosexuality is wrong because your father told you. That's inappropriate. Or you can't say that in the same kind of way homosexuality is wrong as the Emperor Justinian apparently said because it causes earthquakes by making the gods annoyed. You can argue, we do argue, about matters of morality and about matters of art as well, all areas of evaluation. We give arguments as to why we think it's much, much better to view King Lear in a particular way rather than it in another way, or we think that certain kind of art is superior to other kind of art. I think it's very important to remember this. It's not that I think the sociological fact, the embeddedness of the way we argue about evaluation is the end-all of the argument. It's not. People are very fond of pointing this out to me and to Ronald Dworkin. But it's a big argument. You need a big theory to overturn the way we generally think. Anyway, I don't believe it's a problem that people can escape, and we might look at the argument that Dworkin puts forward as a very powerful argument. If you think that moral evaluation, moral values are neither true nor false because there's no external entity, the existence of which makes your moral proposition true or false, you actually make a moral proposition yourself. You might say there's no truth about the question of whether abortion is permissible or not because there's no external fact. There's nothing out there by virtue of which we could demonstrate or prove abortion to be permissible or not. And that, of course, is to endorse moral proposition. If you say there's no truth on the question of whether abortion is morally wrong, you're endorsing the truth that it is morally permissible. It's a powerful argument. I can't get round it. And the explanation for it is, I think, that morality is so embedded within us. You can't do it. You can't say, well, I just can't decide on this question of whether my daughter should have an abortion or not, or whether I should give this advice to a person in my doctor's study about whether abortion should be given or not, merely by saying, oh, there's no proof, there's no demonstration whether it's right or wrong, so there's nothing I can do. No, you have to do something. Abortion is permissible if you really believe there's no proof that it's not permissible. It's a powerful argument. I can't get my mind around it, and I've heard Dworkin say this many, many times, and it convinces me. Maybe I'm just motivated to want there to be truth and morality, but I think even then that itself is an argument of a kind, which I will come to. So value versus science. I intuited at the beginning, I could see at the beginning what Dworkin was getting at when he was talking about principles and then policies. You could see that evaluation was now what he was saying was what the positivists couldn't deal with. Is it right, as he says, that the Humean principle governs how we should understand about law? The Humean principle distinguishes fact from value. A famous passage in Hume where what he says is, he doesn't actually use it in this particular kind of way, but he says that mere convention is vulgar. What he means by this is fact. You can describe conventions in a way that doesn't bring out the value that underlies them. He says it's when you jump from talking about conventional behaviour that you see the conjunction of ises. This is the convention in this particular locality. This is the custom in this particular locality. And then you hear people saying that you ought to do this, or you must do this, or you're right to do this. And he says you're talking a different kind of language. And what he's referring to is the idea of description versus normativity, or as it's now called the is-ought debate, or the fact-value distinction. Well, this is very important to Dworkin. I think it always has been, but in Justice for Hedgehogs, his great work, his great statement, the Humean principle governs all. And so we discover that from what he says, that what I knew all along was that legal reasoning is a subspecies of moral reasoning. And we can take it further than that. It's a subspecies of political reasoning, which is itself a subspecies of moral reasoning. And moral reasoning it follows from personal ethics, because Dworkin draws a distinction between morality and ethics. Ethics is your personal morality. He finds it useful to draw a distinction between what it is that you think is right for you to do, what is appropriate. And it comes from within. And I think his idea of equality and liberty come from within. So, for example, if you have some respect for yourself, then you also have respect for others. You must see others as yourself. They're equal to yourself as a human being. All sorts of other differences that are completely irrelevant. And I think equality comes from that idea. So morality emerges. And then morality, well, if you live in a community, political morality determines the moral structure of how you ought to organise the way you live. And that will involve a legal institution, a legal structure, all the way from personal ethics. In a sense, Dworkin's saying that morality and personal ethics drives everything, determines the content and the structure of any particular legal system. So, what is the relationship between facts and value? Well, I was always very struck by Jerry Cohen's article when I was at the paper, where he proposed the idea. It's a version of the a very intellectualized version of Hume, where he says that ultimate statements of value do not include statements of fact. It's his way of putting the distinction between fact and value. But it also draws attention to the fact that mostly moral statements, moral propositions, include reference to empirical propositions. All right, so it's impossible, virtually impossible, at a less abstract level, to make moral judgments without reference to particular facts. I give the example in my paper of abortion. That at the most abstract level, you don't need any empirical facts. You don't need to know any to say that you must respect other people. It's how it works out at the lower levels. But it means that any empirical fact, because I think there can be moral facts, so I'm talking here about empirical facts, the difference between empirical propositions and value propositions, any empirical fact is there in the story only by virtue of morality. All right, so I'll give you some examples of this. One I like, because of the irony it comes from positivists, is the difference that Bentham and Austin drew between two kinds of convention, what they called positive morality versus, or conventional morality versus critical morality, or as they put it, real morality. And conventional morality is not morality at all because it's defined by fact, by empirical fact. And it doesn't matter, and it's going a little bit ahead to George's paper, it doesn't matter whether it's convention by consensus or convention by agreement. In each case, it's defined as a matter of fact. So you can have moral conventions, but only by virtue of the fact that they're moral. All right, they're identified by some moral judgment that clothes them or gloves them, as it were. Or what is it amongst the facts that is significant for law and morality is whether they have got moral significance, moral importance. Right, reasoning about value. First of all, I put an argument here. It'll strike you as a bootstraps argument. One is that there's a moral justification for objectivity, I think, in morality. We can't refer to science. I think it helps not to think of science, not to think of empirical propositions whenever you're trying to approach the problem of the objectivity of morality. We could adjust our theory of truth, as Dworkin does, to any particular domain. He says that truth is a function of the point or purpose of any practice. What is the point or purpose of practice of law? It's to govern the relationships between human beings, and particularly in relation to the application of coercion in a particular kind of political structure. Would it be good to operate with a truth? Would it be morally right? Would it be morally attractive to view legal propositions as matters of taste alone? That is, to give them the truth value of neither true nor false. No, it would make a total nonsense of the courts for a start. It would make a total nonsense of legal argument in law schools, actually. If there's no objectivity to legal propositions. And alternative account of truth would be one which says truth for law is only demonstrable. And that would, I believe, set us back to the 12th century, because it would set us back to a very rigid form of positivism. Legal propositions are only true if they can be demonstrated to be true. So we've got to have something between legal arguments as taste and legal argument as demonstration. And we have it. We do it. All right? So this is a justification for moral reasons. You want to be able to attack other lawyers' judgments about what is legally right or wrong. And we do. We have methods. We have methods in the cases. We say you've placed inappropriate weight upon this. We have a weight of precedents which serve a number of purposes. One is that some bright person had worked away at this in very precise circumstances. Secondly, the previous case might generate some argument of fairness. Well, they got off, so I should be able to get off. Or the prosecutor might say, well, they were put in prison, so this person should be put in prison. We can do it. And to refine the idea is what I believe Dworkin is doing when he produces his unity of value thesis. I get to that through the two models of legal reasoning, of moral reasoning that he offered as early as 1973. One, a view of moral reasoning that's based upon external fact. One that's based upon constructivism. These isms I hate, but nevertheless, and he didn't like them either. But you make your argument in accordance with the materials that are available to you. Right? What are the materials available to you? Your convictions and judgments about the importance of previous events. Your own convictions. I believe the convictions of others. Are the judgments I make fallible? Yes, they obviously are. That's why we have the setup of the courts. So you can attack another person's arguments on the grounds of incoherence, inconsistency, lack of authenticity. That is, you're just saying it because you're a blowhard who's just been to Eton and Oxford and never got out into the real world and discovered who the Beatles are, that sort of thing. There is plenty there. This satisfies the requirement that we don't just rely on legal argument as taste, or the opposite horror, the 12th century idea that it all comes by some agreed convention amongst us. And unity of value, despite the mystery that's made of it by Joseph Raz in a recent paper, I don't think is as we might say, as big deal as he makes it out to be. I see it from the point of view of a barrister. I have to be consistent. I have to smooth my argument out. I can't make a serious, responsible judgment about something as important as morality by holding on to two contradictory ideas. This is the influence of Isaiah Berlin, where the idea is there's a kind of moral reality out there of conflict. There's conflict. I noticed that Roger Scruton was doing it, the English philosopher, in The Guardian yesterday evening, just saying, well, the problem about morality and so on, the socialists try and the left-wingers try and smooth everything out, but the fact of the matter is, if you give equality to some people, then you're taking away freedom for others, and there's just that basic conflict. And I don't think that's right. If you're going to make a sensible, responsible judgment, you've got to smooth it out. You've got to be consistent. Any lawyer understands that, because you're looking for inconsistencies in another person's argument. There are no conflicts out there, which is what I believe Raz thinks, despite what he says. It's your responsibility to get rid of them. So there are surface conflicts, but no genuine conflicts. Right, there's many things I could say. I've spoken far too long, but I thought I'd just end with those two examples in my paper. If you haven't had time to read it, no matter. But just an example of unity working, unity-type argument working in a famous case in England, Fisher against Bell in 1961. Police government wanted to stop the circulation of flick knives, so they passed the Restriction of Offensive Weapons Act. Section 2.1 said it's a criminal offence to offer for sale a flick knife. And a guy in Soho in London had a flick knife in his window with something like 7 and 6pence on it, in old money. And he was prosecuted, and they let him off because under the law of contract, not the law of criminal law, not the criminal law, this was the criminal law under which he was charged. Under the law of contract, if you put something with a price tag on it in your shop window, that's not offering something for sale. It's offering the public the chance, what we call an invitation to treat, to come in and make an offer for that thing at the price of 7 and 6pence to the shop. So according to the law of contract, that's not an offer for sale. So he got off. Now you can see the attempt at unifying the crime and contract. All right, you want to kind of smooth the whole thing, but you can do it another way, which is to say that they're different categories. What was the apparent conflict between crime and contract? Let's just solve this. A contract is about making contract. All right? Crime is about stopping the circulation of weapons. So people thought this was a silly decision because it allowed criminals, to be able to continue with flick knives, and you had to go through that cumbersome procedure of going through the legislature of Parliament again to get this thing amended, which in fact it was because of Fisher against Bell. But another way to explain it, which also smooths conflicts, was to decide, although they didn't say it, but it's how I read the case, because one of the wonderful things about Dworkin that's infected me is that you can read cases in ways that aren't even mentioned in cases, because the moral proposition, the problem is there, and your job is to produce the argument to solve them, is that you would, because there was an ambiguity, one might say, about unifying the argument in two different ways, you resolve it in favour of the defendant, because after all, this is criminal law, and the criminal law is not like contract. It stigmatises people, and we have a principle to that effect that you should always construe a criminal statute in favour of the defendant. The second example is one that's always struck me. I remember Jim Harris thinking it was the silliest thing he'd ever come across in his life. I disagree. But I remember Dworkin in the early years when he was hammering out the idea of the one right answer thesis with a very distinguished philosopher who tragically died when he was 31, called Gareth Evans, who I'm told solved a problem known as the causal theory of knowledge. Or causal theory of proper names, I'm not quite sure, but fearfully bright person. And Dworkin said, imagine a competition, a trivial competition. You see them all the time. I bet each of you have entered one at some stage in your life, because you get a prize if you match up some tediously boring things like pop stars' heads with pop stars' feet, and these parts of the competition are usually not too difficult to do, and people get excited. And then there's a tiebreaker, jingle, some sort of jingle like Dulux, colour paints are better because, and you have to complete in 12 words something really smart after that, and then if you've produced the smartest one, then you win the prize of £500 or the luxury holiday getaway or something like that. And Dworkin said, and I still find it very compelling, he says people went into this competition on the basis that judges would decide which was the best of the jingles. So, they've got 12 people who've got matched up the faces and the legs properly, the feet properly. He says you have to keep looking. Now, I remember him doing it. He says you have to keep looking. You have to go through these tedious things, and you've got to work out which one's better. You've got a responsibility to do it. And there's a lot of truth in it. You couldn't just say, oh, this is just rubbish, and just put it to one side. No, you're a judge charged with this particular responsibility of finding the best. And he said he didn't find it. Didn't think it was terribly much hung upon it, but it's insight into his methodology, his ways of doing things. It's terribly empirical, going from the ground up. See, there is something there. You have to find something there. You have to make it. On that note, I be quiet. Okay.
Thank you very much. Thank you very much, Professor Guest. Any questions? We can open up for discussion. I can have a queue, people who want to ask a question. I have Dimitris and then Professor Sager. Since it's being broadcast, we want the microphone to...
So the question is very simple. Do you think that there's anything wrong with someone being a Dworkinian and thinking that there might be some moral questions, including some moral questions that bear on the content of the law, where it's indeterminate what the right answer is? So let me give you an example. There are different types of car safety regulations, and suppose that as a matter of morality, it's indeterminate whether seat belts or some other type of car safety measure is morally superior. Is there anything wrong with a Dworkinian saying, yeah, that moral question is indeterminate? The answer to that moral, it's indeterminate which is morally superior, but that's we have to accept it. If law is a species of morality.
I have to interrupt. I always have problems with the meaning of indeterminate. I use basic language. I mean, indeterminate, you mean it's evaluative.
Yeah.
It's
So
just unclear, like the roller skates case.
It's not true that one type of safety measure is superior to the other as a matter of morality,
Yep.
Or that the other is
It's
superior
just
to the
not
other,
clear.
or that they. No. It's suppose that we have a moral theory that is committed to some form of moral indeterminacy. Where
You see, I'm sorry, I don't understand what that means, and I think I have to be taught, because I know indeterminacy is a term that people use. It's very common. I've never understood it.
So it's
all moral propositions are indeterminate, and that's the way I'd understand it. Because you can't prove anything, you can't determine what any is. But you tell me. I'd love
indeterminate
to know.
in the sense that it's neither true nor false that one is better than the other,
Oh, yes.
or that they're equal.
Yeah. There could be such propositions. It's very difficult to imagine what they are.
I'll give you an example of different car safety mechanisms. So safety belt as opposed to some other. The legal question is, should a car manufacturer be under a duty to install safety belts or some other car safety mechanism?
Yeah.
And then it's neither true. Suppose that we have a moral theory that says it's neither true nor false that the safty belt or the other
Airbags.
Yes,
Airbags,
is superior.
So
Is there anything wrong with?
You can install either, all right? So you could install either. I mean, the duty would be for the motor car manufacturer to produce a safe vehicle. The standard regulations would say it's got to, prevent this kind of impact. In measures in decibels or something, and then I can see that airbags might do that, or safety belt might do it, or some other thing that's been invented. But well, in which case the right answer to the moral question, I suppose, is that if they're equally safe, there's no right answer to whether. Does that advance things at all? Or?
It does. It does, but so what you're saying is that there might be some areas in morality where there's no one right answer, but
well,
that doesn't.
There's a right answer to the question of safety, isn't there? I mean, if these are genuinely equally productive of the same level of safety,
they're not equal.
So,
they're not equal.
Yeah.
So
one has produces slightly more safety than the other, and the right answer is the one that produces most safety, compared perhaps with some other rights that people have to cheap cars or whatever.
But that's not indeterminacy. Indeterminacy is a phenomenon where it's neither true nor false that one is superior than the other, or that they're equal.
Right. So, okay. I think I have to endorse. I mean, but I don't know. Sometimes when I'm defending Dworkin, or I'm being Dworkin, or I'm just making up in my head. It's been a problem my whole life. I mean, it doesn't seem to be particularly difficult for me to say there could be morally neutral. Use some normal word like there are no, in which there's a moral proposition is neither true nor false. And I'm just trying to imagine the proposition if you could word it.
So
either A or B would fulfill the moral requirement of C. That just seems to me like one moral proposition that's true or false. It doesn't, it's not, it's just, well, I say it's true in some cases. Where it's false, the regulators might want to say, well, in that case, choose the airbags. It's the difficulty I have. It won't be the difficulty. I mean, I just don't follow. I can't get a clear concept in my mind. But I have to accept it, yeah.
I think Scott has, Scott has a point.
I just wanted to see if I could come to the rescue here with the kinds of propositions you might be looking for. So suppose it's a horrible situation. Both of my children are drowning, and there'll only be time to save one of them. Right? It seems to me that it might be, false that I should save the oldest before the youngest. Or let's do this. It might be neither true nor false. Right? You should save the oldest, or you should save the youngest. That you're in a situation where there are two valuable courses of action, and morality simply underdetermines what it is that one ought to do in that kind of case. But also, there seem to be less tragic instances of this. Yes. Right? There are two careers open to you. Both are valuable ways of moving through the world. Yeah. And you choose which values you're going to realize in your own life. You don't try to track the thing that has the most value.
I have to say that there's no right answer to the...
You would say there's no right answer. And don't you think that legal systems must encounter situations like that all the time, where there's incommensurable values? You could realize the values of liberty, but it's a circumstance in which pursuing those values will mean you'll inevitably compromise some other sorts of values, or you could pursue those other sorts of values.
The idea of compromise, I don't. Yeah.
Can I add something on the one point? So why not say instead that morality? So that morality has an answer to both these questions. Yeah, right. It says that you're okay if you save either of your children, and it says that you're okay if you choose either or any from among a set or valuable courses in life. That's the right answer. It says that it directs you to other factors that you are permitted to base your choice on.
I might be okay with the thought that when there are incommensurable options on the table, both of which are permissible, you don't do anything wrong when you pursue either. But there's a question that you have to answer. Right? The question is, what will you do? And it's not answered by what should you do. And so I guess let me shift the question back to you. Right? Do those circumstances which we seem to agree you can find yourself in, where you've exhausted what should you do, and it leaves open multiple courses of action. And you have to decide what will you do. Do you worry in any way that those sorts of circumstances compromise the one right answer thesis that Dworkin's got, not as a matter of morality, but as a matter of law, right? So it's not. So in the court, yeah.
I don't think it's a matter of truth. I'm speaking on my feet, really. I just. The right answer is to do either. That's what Nikos was saying.
But in a court case where it's plaintiff and defendant, and they've got they've got claims which for the political community would realize for the plaintiff one set of values, and for the defendant, a decision for the defendant would realize another set of values, and we think that these values are in some sense incommensurable, and the judge is forced to choose. The judge finds himself in a position where
do I decide this way or do I decide this way? I mean,
where there's no should, it's decide what you will do, and you'll realize one set of values by doing either thing. But it seems like if that can arise, then the no right answer thesis is false as a thesis about court decisions.
Those kinds of cases, first of all, they seem, I mean, a barrister would think of those things as no cause to answer. You know, either there's nothing here that should be the subject of a court case. You know, how could one have a right to the decision? I should have been saved first. You say, well, the right answer to this is that the poor guy, you know, it was just a matter of tossing a coin or whatever to decide between them. That would have been the right answer. The right answer there, it's, you know, when you're arguing it, you know, so don't take this to court, because the answers, there's no right answer on these questions. But those seem to me to be really very rare cases. The cases of what I think Ronald Dworkin at one stage were ties. You know, I thought rather ironically called this the one right answer thesis. You know, you don't need the one there. The right answers. Does that satisfy you? What point you've made the same as?
Can I intervene to ask for clarification about your hypotheticals?
Yeah.
So, in the case of the children, you agree that the parent does no more wrong acting either way.
Yeah.
So morality permits to save either, and that means that on an alleged court, if either child says, "Dad, you have saved me," the parent can say, "I did no more wrong saving your brother."
Yeah.
So if either were to assert moral rights or duties on their part, they would be making a mistake.
Well, let's be more creative with our judicial procedure.
So so if neither of them have moral rights or duties breached by the parent, then the equivalent in law would be a case of the litigant asserting moral rights or duties. And it would follow that the judge wouldn't have to be put in a position of selecting one of the two as incommensurable, because it would be the case that none of them had any moral right or duty being breached. So
in the States we have this procedural mechanism which is I believe that the technical name for it is interpleader. So I hold some money and I know that it doesn't belong to me, but I see that some people are squabbling over it, and so I bring them both to court and I say to the court, this money is not mine, decide which one of these claimants has it. Yeah? So we could pursue the example with money, we could pursue it with my children. You know, but you might fall back in lots of plaintiff versus defendant cases on plaintiff is here asserting a right and we don't think that there is a right because we're in but that's an accidental feature of certain kinds of civil procedure. And, you know, we could have a circumstance in which I've interpleaded two parties, and now the court must decide who has the superior title to the money. And the question is, there might be one set of rules that would realize one set of values that would say give it to party A, and one set of rules that would realize another set of values that give it to party B. And the question is it possible, right, just that the decision the judge must make is which set of values to realize in this community. Well, it may not be the task. Well, the task of the judge might be to decide cases, and there may be.
Yeah.
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 About realizing values, you know, like let's take this forward and make things better.
I mean, the question to the judge is, does this person have the moral right he claims?
Yeah, this is why I'm inviting you just to think about another kind of procedure, right? Where, you know, when the plaintiff shows up, the question is, does this person have the right that he claims? But I'm suggesting that there are instances in our legal system, it's just an accidental feature, right? That lots of cases are plaintiff versus defendant. You can set them up in different ways, right? So that the question is, so we have two parties, right? And we're not asking of one person, does this person have a right? And if the answer is yes, we do what they're asking. And if the answer is no, we don't. We're asking who has the superior claim. And, you know, following through on Dimitri's suggestion that there may be some cases in which we think that neither one is superior and that they're not equal.
there's two things I want to say. One is that you need more specific facts so you can do the cornflakes stuff. Just keep looking and looking and looking to see whether actually, you could have saved that other person first.
Yeah.
And then the other one is I can think of circumstances from my own country. In the old days of the mining, there was actually a specific provision in a legislature in the squabbling type case over who was the first in law and in fact to have staked a claim for gold in New Zealand. And it just simply said in these cases, just recognising the way the world is, that the magistrate could toss a coin into recognition, that as far as the court was concerned, there were equal claims, or no person had a moral right to it, as George says. I wonder if there's more in this than I'm getting, because I don't. The argument is there can be circumstances where there are no morally right or wrong answers, and I suppose there could be, because for any proposition you could say. Then I'd wonder.
What's in for me is I'm sympathetic to so much in Dworkin, and the thing I'm least sympathetic to is the thought that you won't encounter values that are incommensurable, where and Ronnie seems to really resist it.
It's part of the unity of law idea that you've got you can't trust your hands. You've got to come to some answer.
And it seems to me that life is full of choices where, as Nico says, morality may have nothing to say. It might be that it has something to say. You can do either of these things.
It doesn't turn on any value which career you will choose, as long as it's a good, it's a picked out from among a set
what the right one is.
Good career. And then it can turn on whim. It can turn on the fact that your uncle impressed you.
Or toss of a coin.
Right. So we're in a complete agreement about that, and then it's the interaction of that with the right answer thesis. It seems to me, we should let other people get involved in conversation. It seems to me to potentially cause a problem for that. But we can take it up afterwards.
Okay. Thank you very much. Do you want to say?
Maybe after Larry.
Okay, Larry.
I wasn't going to address any of this, but let me just say in passing, this conversation has elided the question of unity of value and one right answer. And I actually think in some ways the unity of value proposition, which I'm sympathetic with, is the harder one to defend against incommensurability. And that's actually what Stephen was saying. Stephen was saying it's really wrong when someone in a newspaper says there are these deep competing values. There should be a place to climb up and see them both from. That's actually in some ways more deeply challenged by the idea of incommensurability. And one right answer, especially in the legal situation, may be different than unity. So I just want to note, Dworkin, after all, is committed to both of these ideas, and they are different with regard to incommensurability. I just want to say that. Now, the question I was going to ask, however, concerns some things about your presentations, Stephen, and Dworkin's presentation over time. You do something very interesting. You pretty quickly move from the notion of an interpretive claim or process to an evaluative claim or process, which you think of as essentially synonymous. And you put a lot of weight, especially in conversation, on the Dworkin in Hedgehogs, who uses the Humean principle quite ruthlessly. They insist that the membrane between fact and value is critical, and you want to line everything up on value and evaluative.
Right.
But the interesting thing is, and this is where my question is going, the Dworkin who, in Law's Empire, who introduces us to interpretation, makes a great fuss over the fact that what distinguishes interpretation from other processes is the fact that it crosses the membrane between fact and value. What's really quite singular when you read Law's Empire is this notion that fact and value are alive at all moments and non-dominating of each other. And indeed, if there is a dominance, it's fit, which, that there's a threshold of fit. And then after the threshold of fit, there's a playing off of fit and value. Now, the last thing to say is that Dworkin and Hedgehog seems to have lost sight of interpretation. So I'm wondering what you make of all this. Was all the stuff about fact and value and interpretation a false start that comes pure in Hedgehog's as evaluative? Or is there something left of all this? You seem quite happy to leave interpretation behind. Maybe that's the right thing to do, but I'm wondering, you did so in this simple move from interpretation to evaluation.
Yeah, it's not meant to be a move. I don't like interpretation in some sense. I hate the word interpretivism. I feel Dworkin's going to be put into an interpretivist school, and then you've got the geometric school and the sociological school and so on like that. He's doing something really spectacular. Interpretation is evaluative. It's evaluative through and through and through, but he's got a particular view of what evaluation is. It's tied to practices, factually determined, empiric practices. All right? He's got that view of morality. Right? Justice, judgments about justice, controversial judgments about justice, they're inherently controversial, are about the practice of justice. It's conceptual. Wrong word to use in relation to Dworkin, but it does cut corners. Dworkin discovered evaluative concepts. And evaluative concepts are those ones that don't have a counterpart in the world. They explain or refer to the practice of justice, the practice of promising, the practice of law, the practices of democracy, and so on. So always evaluation is there. I use the term glove at the moment. It's the glove that picks out the facts, the empiric facts, the practices, and makes them significant. So morality is always there. No, you don't have to keep saying Ronald Dworkin's theory is wrong because it doesn't fit. You have to say it's wrong because it hasn't regarded as sufficiently significant certain historical events. He always said from a long time ago, before, at the time of the Law's Empire, but even before that, he drew a distinction between substance and fit. And he uses this not just in relation to deciding and explaining cases, but in general. First thing he does is, what are the facts there that we need to explain? All right, the theory will fit those facts, the way a judge will fit his evaluative, interpretive judgment upon the facts. Right, and then you make an evaluation of them. You give them significance. Sometimes significance is internally skeptical, as he says, and might even be globally internally skeptical and just deny the practice. Still exists, but it's of no importance, like Nazi practices. Right, so that the facts don't constrain evaluation. It's evaluation that comes first. And that's why at the beginning I said this is what I found attractive. He's clearly talking about value, principles. Fit as a form of substance. That's just a different strata of substance.
If I can interrupt you, I'm a little confused because you said a few moments ago, you begin with asking the question, what are the facts that need to be explained? And then you produce evaluation.
There's two things go together.
But then you sum all this up by saying it's evaluation that is driving everything.
Yes. No,
what about that pre-evaluation step?
The fact says nothing. Any fact says nothing. It's got no significance unless it has significance, unless you pick it out. That's his theory. That I've got no doubt. I think evaluation has been there all the way through. We might call it interpretation.
And the idea of a practice, does it have any pre-evaluative content?
I don't think so for him. But I mean, I don't know if that's important. I mean, he often said the pre-interpretive phase was itself interpretive. It's just layers within the value domain. It goes further and further down. The facts are always secondary to the moral judgment. I think you make a mistake, and I think many people do. And it's interesting in Scott's book, which is easily the best collection of essays, in my view, on Dworkin. Over half the contributors are puzzled. They go time and time again, but the facts don't support Dworkin's theory. And Dworkin gets puzzled about it, or got puzzled about it. It's value that picks the relevant facts out. You're always working on particular facts.
I want to be clear, when you said you make a mistake, if you meant one makes a mistake, I wasn't electing between these two views. I was just struck by the thought that there is an ongoing tension between the notion of interpretation and the idea that it is evaluation all the way down. And I wondered where you were located on that, and now I understand. But I didn't mean to elect a position.
A position, sorry. Okay. Yeah.
George, you have something?
On Larry's question. In terms of the text, if you read Law's Empire and later work, there's a difference in how he states the view. So in Law's Empire, he talks about interpreting practices. In later work, it's about interpreting value. So what you interpret is put differently. In terms of how we should read his work, I agree with Stephen. There's no break. And Dworkin himself would say in conversation, the distinction between fit and substance is not the distinction between evaluative and non-evaluative. Because what fits a practice is itself an evaluative question.
Yes.
That's the way he would put it later on. That's not how it's in Law's Empire, but that's how he would present it in conversation. And when you said, Larry, that, but when you actually apply the method, you begin with the facts, and then you bring evaluation to bear. That begin with the facts seems to me ambiguous between the facts having constitutive relevance and having epistemic relevance. And I think Dworkin meant the latter, that we begin with the facts because they are presented to us by some claimant. Oh, this happened to me, and I said this right. But whether these facts are relevant will be determined ultimately by evaluation at the end of the process. So they begin with the facts claim is that epistemically it's not constitutive of what the rights you have. So hence there is no break, or at least there's a forced contrast between facts mattering somehow, and then evaluation will tell us how, and evaluation taking control all the way down. I think it takes control all the way down because the facts we begin with it's a heuristic device, are epistemic. The relevance is epistemic, it's not conclusive of whether they are actually relevant.
Well, what do you take to be at the bottom of the all the way down? You know, Dworkin in Hedgehogs and in Conversation for a long time would go to some very basic moral propositions. But asked about their stature, he would say their stature is in some basic way interpretive of what people feel and do, not that they have some kind of independent. So there's a sense in which at the very bottom of that is a proposition which is neither factual or evaluative, but is actually a kind of
conviction.
Well, I think that's right, conviction, but deeply shared primitive conviction, which itself is, in some basic way, interpretive anyway.
But do you see the difference, sorry to lay with one, between interpreting values and interpreting practices? Because that's crucial. If the interpretation is ultimately your value, then that makes facts fall out of the picture because the method is all about the interpretation of values. Facts come into it at the late stage of the value will tell us which facts are relevant.
Well, not if to use Stephen's phrase, we're looking at base convictions or basal convictions. It is a fact that those convictions are widely shared, and that fact is critical to the foundational stature of
that they're widely shared. That seems to me to be wrong. I mean, there's nothing out there that's going to determine.
I agree with that.
There's no out there.
No, I agree with that entirely. But that's by way of saying the last moment is itself in some way interpretive.
I suppose, and I'll finish here. I suppose that what's crucial is whether the fact that they are shared, this conviction, is relevant to the method. So you're right. Factually, we interpret values we all share. Is that constitutive of the method in the sense that could we do the same job by imagining convictions people might have, which may not have them as a matter of fact? Would that be relevant in the process of interpretation in his sense? I think it would. So it's not essential to the method that a fact obtains that these convictions are shared. That would be the realist reading of me in the moral sense of his method. So I don't think at the abstract level of interpreting value, some empirical fact actually is essential to the method.
Judgment, very basic.
Thank you. Imer. Bueno, si quieren hacer una pregunta en español, intentaré llevar a cabo la traducción si es que les interesa. Sorry? I didn't see that one.
Imer Flores.
Perdón, Imer. Hay más preguntas para apuntarlos en la lista. Okay.
Imer Flores, first of all, I would like to welcome you to this institute and also congratulate you for the paper. I think it's very well written and very clear and goes directly to the points, and I think it's a very good restatement of Dworkin's position, and especially the defense of being very coherent all the way through the different. So I think I completely agree on what you're saying. I would like to press you a little bit on why you don't like the interpretive words, because sometimes I have the feeling that it was on purpose on why Dworkin didn't use like the more interpretative words. Like that's probably the one that goes directly into interpretation, and by avoiding the TA, he was making like this new term, which is much more amenable to the idea of evaluative, which I think at the end is
I think the answer is that he wanted us to see evaluation had in some way to attach to human practices, whether they're practice of art or law or morality. I think that's a breakthrough. But otherwise you're away with societies of angels and so on, or you're on hopeless ideals, and it takes too much imagination to imagine practices that don't exist, that are beyond the concepts that we currently use. I mean, you'd always scoff at the idea. I mean, people say, well, what would happen in a society of angels if where there wasn't any need for coercion? What sort of law would there be there? And I think Dworkin wanted to get rid of those kinds of remote possibilities. Possibly you can make judgments about those, but only by extension from your engagement with what he called interpretive concepts. And my reason for suggesting we might not overuse that word, I love it in many kinds of ways, because as I said before, it draws together art interpretation with law and makes the whole thing a part of a humanist interpretivist. But it so connects with the famous distinction that many people can grasp without using the word interpretation between fact and value. It employs the Humean principle, which is intuitively well embedded in the way we think, and there's so much to support it. So maybe that answers your question. The question is interpretation. It ties us to things. Look at our own practices.
Okay.
But don't think that facts determine anything at all without the moral glove behind them or the evaluative glove behind them. And that rules out practices that we don't really know about. I mean, I have no idea. Joseph Raz does, but I have no idea what goes on in the society of angels, because their ideals so remote from what it is that we know that it hasn't entered our conceptual structure.
Yeah, and also I wanted to say something on the problem of incommensurability that Scott was trying to point. And I think the answer for Dworkin is, again, going back to Larry's point on the unity of value. And on your example, Scott, if we are going to the judge and we are asking him to decide, it's because we already think that he will finally, at some point, after looking and keep looking, he will reach which one is the right answer.
Yes.
If we are going to the judge and, do whatever option seems fit, I can do the same thing by flipping a coin, so I don't have to go with the judge. The fact that we go with the judge is somehow it has underlined the idea that there's the one right answer there.
Well, maybe. A lot of people try to go to judges, and they're fortunately fobbed off because they're going to waste a lot of court time because there's not a legal issue there. Because there's...
Yeah, but I was trying to point to Scott's example of the fact of going to the judge, and there's two different sets of rules. Rule A and Principles A going in one direction, Rules B and Principles B going in the other direction. But the fact that we are all going to the judge, we are already presupposing that there's some sort of right answer according to the law. Yes. And of course, you have to keep looking to see which ones of the principles and which one of the rules make the most coherent answer. Yes. And again, it goes back to the idea of the unity of value. And I had another question to your paper, to the piece. So at some point you mentioned, and I completely agree that we are not supposed to compromise values because that's contrary to the idea of unity of value. We cannot trade off them because that's also kind of incompatible with the unity of value. But and you also put in the same box the balancing thing. And I'm not sure if balancing is also the same compromise, the same trade-off, because the idea of the proportionality somehow keeps the two values in place, only that gives much weight to one than the other at the case at hand.
Yes, proportionality sounds better. I mean, these are metaphors, I think. The balancing metaphor I don't like, and Dworkin didn't like, because it suggests incommensurability is there. And it's what politicians use all the time. We have to balance security against, private rights and so on. And as though, well, we're the camp that thinks this, and there's just a conflict there. It's like Roger Scruton in The Guardian yesterday. You've got equality here, you've got freedom here. Try and see them as part of one general scheme that encompasses both. And then if you look into them, and he gives us supplies us with the means to do it. Equality is a part of human dignity, but so is freedom and taking responsibilities for one's life. And you begin to see that there might be some. You can use the word balance, but it's usually used in the terms that
but it's more related but it's much more related to the use that politicians do of the word than to what you really do in the balancing. Okay. Thank you.
Yeah. I have one question here in the middle.
Hi. My question is about values, and we are criminal politics students, not law philosophy students. And when we talk about law philosophy in our master, we are kind of the crazy ones because criminal politics is about facts. And my investigation was about the lack of values. But at the end of my master, I understood that it was not a lack of value in our legal system, but that our authority does not understand the real values our legal systems are based on. So my question to you is that why we still have this epistemologic problem, like believing and not understanding which are the values our legal systems are really based on, and that it has to be what you said about conventional moral and the necessity of facts when we talk about criminal law and criminal politics. Because I do believe that it's really important that if we do not understand that in criminal politics and public policies, we're not going to get any real answers that what people need. We're still in the defense of collectivity and fighting against the individual. I don't know if I have...
Right. I don't think what you're saying is, I think I would agree with. We need to have a good grasp of facts and a good grasp of values, those values that make the best sense of the criminal law, because of course people have different views about what the criminal law is for. But we need a good grasp of the arguments and values that are inherent in the criminal law, and facts about, the value of prison, or the non-value of prison, and all sorts of things, in order to be able to come to a proper decision. Nothing I've said here, nothing that Dworkin said ever downplayed the importance of sociological analysis and empirical facts. Nothing. That sociology, of course, is different from anybody must tell you that from the production of legal argument. I think the distinction is in the idea of value or interpretation and empirical facts. But of course, any sociological study requires some drive, some focus, some modus operandi for it to have any kind of sense. I mean, a sociologist who just went out and recorded everything he saw wouldn't get out of bed in the morning because there are so many things to see and so on, but they wouldn't make any sense. So you have to make sense of these things. So there's interpretation and sociology as well. Does that answer your question? I mean, I'm basically agreeing with you, but you maybe...
It's okay. It's better that you don't disagree with me. Thank you.
I have George, and I don't know if there's anyone left that I didn't get. So, George.
I want to ask Stephen a question going back to the challenge of incommensurability. And Scott's, I'm puzzled by Scott's challenge. And there seems to me something misleading in presenting the challenge in terms of a scenario where two things are happening. One is we're determining rights and duties, and the other thing is we're trying to select between different values to realize. And I think that scenario where both are at stake is a bit incoherent, because the idea that the point of morality is to promote values of well-being, so security, safety, basic needs, is one worldview about what moral value is. So it's good that people have security, it's good that people have safety, it's good that people have something to eat, but something being good doesn't mean you have a right to it. So a different worldview would say, well, you don't go directly from one to the other. The right precedes the good. When you debate issues of rights, you don't debate issues of what best promotes the good of people. So in a worldview where the right precedes the good, you're not in the job of trying to maximize value understood as well-being. And this is exactly the outlook people who believe in incommensurability endorse, that the whole point of morality boils down to promoting well-being, and therefore that's what you believe. Of course you will believe in incommensurability, because there are all kinds of things I could be doing to promote people's well-being, and I can only do a fraction of those things. I could be giving money to Africa, or giving money for development in other parts of the world, or could be watching a movie or reading a novel. And there are many good things in life, and you could be doing only a limited number of those things. So if you think that by value we refer to well-being, incommensurability would be the natural position to take. But if by value you mean rights and duties, then you understand value in a different way. And then the question of, there are multiple ways of promote safety, therefore it might be incommensurable, that's something to get off the ground. So it seems to me misleading to challenge Dworkin by assuming, these both outlooks are possible. The welfarist one and the more deontological one. And then the challenge is, how can the deontologist, how can the person who believes that moral value is not about promoting the good, how can he deal with those cases? Well, he wouldn't think it's an issue, because he would think it's all about rights and duties, and having a right to something is not to be explained or justified eventually whether it promotes the good. So that's why I think incommensurability doesn't really pose a challenge. It assumes a different worldview to the one that Dworkin assumed. And the question is, who's right? But that is a moral question. That is not a question about, I found an example where incommensurability puts the judge between different options. That might be a description of the options, but that doesn't settle the question whether promoting different values of well-being is what morality is about. So
it's difficult to reply to that. I sort of agree with what you say, but you might say another kind of way that the incommensurability crowd think of values out there. It's external. It's just part of that distinction, isn't it? It's just they're just incommensurable. And Joseph Razor's article is full of this. It's just incommensurable, and it's got to come from the constructive position in order to be able to understand Dworkin. You are trying to make your arguments as consistent and coherent as you can. It's part of unity of value. Is that the sort of thing that you were getting at, or have I?
No.
The well-being thing, the values are, you look at the people and this would help their well-being,
because
this would help
they
their
can be
well-being.
interpretive in the sense that they will believe an evaluative claim is that the point of moral claims is to promote well-being. What says well-being is an empirical question, but they claim that that's what matters is moral question. It's an evaluative proposition. And of course, that's the view, well-known view, which, comes by different names.
Yes, yeah.
Welfarism or perfectionism or what have you.
Yeah.
And on that picture, incommensurability would be the norm, because there's only, there will always be different courses of action promoting different aspects of well-being, and it's not possible to do them at the same time. There will be conflicts of which.
Because Dworkin has an answer to that, going into his political philosophy. I mean, unity of value applies for his political philosophy as well. And so, this would help their well-being is an argument that's got to be seen in the light of other people and other people's rights to equality and distributions dependent upon how you, I've said it, haven't I? The unity of value applies across his political philosophy and the full works. So it's still going to be kind of internal. But, maybe Scott.
I don't think the move to rights has been a problem because rights can conflict. So, and sometimes when they conflict, there are relationships with priority. If I promised my child that I'll take him to the zoo, but my mother is now very sick and needs to go to the doctor immediately, right? My son has the right that I take him to the zoo.
Yeah.
If I take my mother to the doctor instead, I need to make it up to him. I need to apologize.
Yeah.
I need to make it up to him. I need to apologize. But it's clear what I should do in this case. One takes priority over the other.
So they're not real conflicts, are they?
No, I think it's a genuine conflict. I mean, this is, there are people who want to say that in that case my child doesn't have a right, and that's a really misleading way of understanding the moral situation, because I owe my child something. An apology, and more than an apology. Take him to the zoo at the next occasion. Right? I have justifiably breached his right, and then there are consequences.
But that example, Scott, is different to the safety example, because there morality tells you which right takes precedence.
Oh yeah, but now the suggestion is that there may be cases. Right, so once you agree that rights can conflict, right, there might be cases where there's a priority among them, and then the suggestion is that it's possible that there are cases where there's no priority, and that one has to decide that the world will throw at you situations where you have to decide whether you're going to be a good friend to George or a good friend to Stephen, and that there are considerations of similar magnitude, and you will inevitably breach somebody's right, but you don't have sufficient reason to breach Stephen's right or sufficient reason to breach George's right, and so you choose whether to realize the friendship to George or the friendship to Stephen.
I mean, one is submerged in the light of the other. My right disappears.
Yeah, that's the picture that I want to resist. I mean, and partly, I'm a common lawyer. I come from tort law. Right? You can have a very strong reason for breaching somebody's rights, and nevertheless, right, you wrong them. Right? So, that's the case with my mother. I do wrong the child when I fail to do what I promised to do, and that's why I apologize, and that's why I say, I'll take you to the zoo on the next occasion. If the zoo is closing, then I'm going to do something similarly comparable. I'm not blameworthy for what I've done, but there are consequences that follow.
How does that relate to right answers and so on? It's just, what's the right thing to do?
Well, George says we'll escape this problem by realizing that judges are dealing with questions of rights. And I'm uncertain. I agree with you. I should work up cases that more clearly present the problem. Although I wasn't thinking about it until you midway through your talk. But it seems to me it strikes me as very strange if the legal system could be such that people never face these kinds of moral quandaries that they face in the judges never face the moral quandaries that people face in their everyday lives. But I'm also happy to take Larry's point that there's a separate challenge here to Dworkin, even if you want to concede to him that there's something about a legal system that means there's always a right answer. There's the unity of value challenge.
So please join me giving Professor Guest a round of applause. And go directly to George's talk. George?
Right. Thank you, Juan. So I'm going to talk about my paper, which is to do with revisiting the hard Dworkin debate. Basically, many of the papers are doing that in this conference. I should preface my talk by saying that I grew up intellectually reading Hart and Dworkin. It's what one does in the UK. We teach these two great books to the students, The Concept of Law and Law's Empire. This is where you begin, and often this is where you end. We urge them not to read secondary literature, but go back to the original time and again, which is what I do, and I did for the purposes of this paper. I find both Hart and Dworkin reward you when you go back and reread the same chapters and same passages. And that is a testimony to the greatness of those two books. It's not an accident that these two books are still taught. I don't know about this country, but in the UK, it's a canon. So what I thought I would do is revisit the challenge Dworkin puts to Hart in Model of Rules 2, which the paper was published in Taking It Seriously, reprinted and published earlier in the Yale Law Journal. And I want to begin by a few thoughts on Hart. So part of the general point of my paper is that legal philosophy has gone astray the last 30 years, reading these two texts in a way that I don't think is the best reading of them. Not just Dworkin, but also Hart. And I want to begin with something that Hart himself says in the introduction to the Concept of Law. He goes through these three persistent questions asked about law, one of which is what's the connection between law and rules. And at some point in the introduction, he says, well, if you tell someone that law is about rules, that illuminates an understanding of law no further. So the last 30 years, and not just positivists, but Dworkin himself has been talking about law as a model of rules and attributing this to positivists, but that doesn't say anything. It should say nothing to a lawyer who studies a law degree. If you're, as a law student, you're told law is about rules, that seems like trivially true, but doesn't really illuminate that understanding. So Hart was right about that. And I read him always that the concept of law will give us a theory of rules, as opposed to assume, oh, it's about rules. And that's what I thought he does in pages 55 to 58, where he gives the so-called social rule theory, which basically has two components. It's a convergence of behavior between people and attitudes that they believe the behavior is obligatory. They will criticize people who deviate, and they will assert a duty to comply, to converge. And at that part of the book, it was clear to me that Hart was giving an explanation of duty. So he was doing two things at the same time, telling us what rules are, and then telling us that rules create duties. Because what he was trying to explain is something that he criticized Austin for not being able to explain, which is the idea of a duty. You cannot get to duties from habits. You cannot get to duties from patterns of behavior. How do you get to duties? Well, you get to duties because you can say Rex 2 has a right to succeed when Rex 1 dies, and the judge has a duty to appoint Rex 2 as a monarch because Rex 1 has died. And why? Because there's a rule. So the connection between rule and duty, or rule and rights, legal rights, is inherent, is constitutive, right? So Hart was trying to explain legal obligation or legal rights via the notion of a rule, okay? And we have two things, right, in a way, a theory of a rule and a theory of a duty, but they are the same. I always thought one and the same. Now, when you read Dworkin's challenge in Model of Rules 2, it has the following form. He says, well, I argue litigants have legal rights and duties, and they are moral rights and duties, but I face a challenge from Hart, because Hart's view is that you cannot have any moral rights or duties unless there's a practice of convergence and an attitude of acceptance. So he attributes to Hart the thesis that all moral rights and duties are like that. He says Hart's thesis belongs to legal as well as moral philosophy. And Dworkin's interest in that paper clearly is how do we account for legal obligation understood as moral obligation? How else could you understand it? So it seems to me that both Hart and Dworkin here are in agreement. They are trying to explain moral obligation, and they were given theories of moral obligation, and Dworkin tests Hart's theory, right? So the test goes like this. The test is, well, let's see if all obligations are like that, all moral obligations. So the testing is to take place at the moral level. We don't get to law there yet. The dialectic, as I put it, of the argument in Dworkin's paper is Hart's theory of law stands and falls with his moral theory of obligation. That's the dialectic of the argument. Hart can only be right about law if he's right about morality. Now, 40 years later, if you read some of the literature published on legal theory, they would dispute this claim, this reading of concept of law. They would say, no, Hart was given an account of what obligations people believe they have, right, or believed obligations, or intended obligations, but not what obligations really are. He was talking about obligations from the point of view of the law. The law thinks that there are obligations, or people in church who go and remove their hats believe they have to. That wasn't the reading Dworkin took in the model of Rule 2, and he didn't even have to explain himself. He didn't say, oh, I read Hart as given a theory of moral obligation. He just assumed that's what he was doing. So that's the dialectic, and the first challenge to this, I view, that all moral obligations, including the judges, are to do with practices of convergence and acceptance. Dworkin says that can't be right. Right? That can't be right because then he points to examples. In many practices, we assert moral obligations when there is no practice of convergence and no attitude of acceptance. And he gave the example of vegetarianism, which might not work so well 40 years later, as now many people practice vegetarianism. But the idea was that, look, someone can say to others, there's a duty not to eat meat, even though most people converge in eating meat, and even though most people accept that eating meat is fine. And of course, vegetarianism is perhaps not the ideal example to use. Take torture, right? Even if you live in a community where they practice torture and they believe it's fine to torture people in a particular group, that wouldn't make torture morally fine, right? So it couldn't be the case that all obligations arise in virtue of practice of convergence and acceptance. So that's out of the picture as a theory of moral obligation. But what about if some obligations arise as a matter of convergence and acceptance? Then Dworkin says Hart would be right, because he would have identified a subset of obligations which arise when people converge and believe certain things. So at that stage in the paper, the possibility is still open, right? So Hart identified one kind of moral obligation, and law falls within that kind, all right? So let's see that if Hart is right. So my interest in reading that paper 40 years later is to see the clarity in Dworkin's approach, right? So at that point in the paper, Dworkin says, Hart could be right. He was wrong to say all obligations are like that, but he might be right to say some moral obligations do, and law is like that, okay? Now, at this point in the paper, Dworkin said, well, Hart theory fails to draw a distinction between practices of conventional morality and practices of concurrent morality. And he defined them as follows. So cases of conventional morality is cases where people converge in the same behavior and believe that it ought to be taken. But they do so because they believe the fact of convergence is why they should do it. So they count the fact of convergence as their reason for having to do it. So in the church example that Hart gave, people who go to church remove their hat, they believe one should remove their hat, and they do so with the understanding that the reason why they should do it is because other people do it. By contrast, cases of concurrent morality, cases where you have the convergence and the attitudes, yet people don't count the fact of convergence as part of their reasons for doing what they do. And Dworkin's sense was Hart should limit his theory to cases of conventional morality, not to cases of concurrent morality. And the way he put the point was it would distort the claim of people who are engaged in concurrent morality. For example, people refrain from lying, like people in this room, I hope, but they don't count the fact that others do so refrain as their reason for not doing it. They kind of think it's wrong to lie. I hope this is your view. I hope you don't count the fact that most people don't lie as your reason, but I hope you believe that it's disrespectful to lie to people, right? So Dworkin's point there is it would distort your reasons for not lying if we were to say that you do so because you count the fact of convergence as your reason. So then the next move in the argument was for Dworkin to say Hart should weaken the theory further to make it apply only to cases of conventional morality. Okay? And then the final move in that argument is that Hart gets wrong even that case. So even in that, if it were to be so limited, that theory, to apply only to cases of conventional morality, it's a poor and inadequate explanation of obligation even in those cases. Okay, and I'll come to why he thought that in a minute. So at that point in the paper, we have the following possibility open. There are obligations, moral obligations, in cases of conventional morality, but Hart gives the wrong theory. Okay. Now, the history of what happened next is well known to most people in the room. Positivists were divided. Hart, in the postscript published after he died, endorsed or accepted Dworkin's suggestion to weaken the theory to apply only to cases of conventional morality. So to speak, he endorsed conventionalism in the postscript. And then legal positivists were divided between those who thought it was a good move and those who thought it was a bad move. And those who thought it was a bad move tried to defend the original edition of the Concept of Law, where Hart didn't say anything about conventionalism. And they did try to do so by saying, look, in the original edition, Hart didn't even care about why officials follow the rule of recognition. It could be for whatever reason. To Hart, it didn't matter whether officials follow the same criteria of validity because other officials do. They could have all kinds of reasons. They're afraid of the system. They want to support it. They believe in democracy as a value. There can be all kinds of reasons why they converge in applying the criteria. What matters is that they converge. And they criticize other judges when they don't. So the positivists who didn't like the turn to conventions tried to defend the original account. Others who did like the turn to conventions tried to find one central idea that could explain why conventions matter to law. So you have the idea that coordination, laws about coordination, or laws about some shared activity of planning. So positivists were trying to unpack this turn to conventionalism in their own terms and remain or fly the flag of conventionalism as a positivist. Now, what I want to do in the paper is revisit the distinction Dworkin draws between these two kinds of practices, concurrent and conventional, because I think there are two ways to read that distinction. So this is part of the paper is doing. I'm going to tell you what these two ways are, and I think one of them is the better way to interpret them, and I think the wrong way to interpret, or the worst way to interpret them, has been the one adopted by many of the positivists, and it has led them astray, not being able to appreciate the real challenge that Dworkin put to Hart. So what is the two readings? So I think it's best if I explain the difference by introducing a distinction between two types of reasons. One I would call motivating. It's not my distinction. It's the distinction people use in philosophy of action. So one is are reasons that are motivating and reasons that are normative. Motivating reasons are reasons that are to do with the considerations in the light of which someone acts. So it's what goes through your head, so to speak, when you take an action. What motivated you to do so? Which facts you took to be relevant? Why you brush your teeth, or why you are in the seminar, why you're studying law. There are considerations in light of which you do these actions. And the second type of reasons, what I call normative reasons or justifying reasons, are the considerations that in fact count in favor of your action, whether or not you had it in your mind, right? So maybe I refrained from lying to my wife this morning about how long the session will be, because I was afraid she would catch me out, and she would expect me to phone her earlier than I would do. My motivation for not lying was that I was afraid I would be caught out. That was my motivated reason for not lying. But my normative reason for not lying is different. It's not that the fact that I shouldn't get caught. It's that I should respect my wife. I shouldn't lie to people. So normative reasons and motivated reasons are of different kinds. Okay, you may be motivated by considerations that don't support your action, or you may take an action which is justified, but not for the right reasons. I think this distinction is well established. I don't need to labor that distinction. But I think it bears on the definition of what is a conventional practice. In the model of rules 2, Dworkin appears to be defining practice of conventional morality in motivating reason sense. So he says when you look at the practice of not lying, people don't take the fact that others don't do it as their reason for not doing it. But if you look at the cases like Hart's example of going to church and removing your hat, people there take the fact that others remove their hat also as their reason for doing it. And this distinction is cast out in terms of motivating reasons. And that's understood, to me, is a puzzle, because it doesn't quite fit with the dialectic of the paper. The dialectic, remember, is to challenge Hart's view as a theory of moral obligation. When someone gives a theory of moral obligation and you present them with a factual information about people in the world having different motivations, why would that be relevant? Why would that be a challenge to Hart's theory? Hart could have gone back and say, oh yeah, it's true, there are these two practices, but my theory still applies to both. Right? So it wouldn't really explain why Dworkin says Hart's theory would distort the claim made by people who don't lie, that they don't take the fact that others don't lie as a reason. I think the better way to understand the distinction he drew between the two practices is in normative terms. There are practices where, as a matter of moral fact, the idea that others converge has nothing to do with why you should do the same. And there are cases where, as a matter of moral fact, the idea that others converge is relevant. Okay? And this has nothing to do with whether people themselves take the fact of convergence as relevant. So let me give you an example. Suppose that most people pay the taxes because they believe they show allegiance to their nation. That is their reason. Or because they're afraid they will get caught. And now I have a question about whether I should pay my taxes too. Now the reason why I should pay my taxes is because I would be free riding if I don't. All the others shoulder a cost of paying for hospitals and schools, and I would be using those facilities without shouldering a fraction of that cost. The fact that others pay is part of the reason why I have to pay as well. So it changes my moral reasons. My duty to pay my taxes partly is explained by the fact that others are paying their taxes too. But whether or not all of us paying our taxes think about that is relevant, right? It's not necessary for my duty that all of us paying our taxes are thinking, all right, yeah, it's because everybody else is doing that, I have to do it myself. They may do that, may not do that. So motivation is not really relevant, right? So, and I think the challenge Dworkin put to Hart is, look, you are rightly giving us a case of a duty where the fact that others converge is morally relevant, but we don't give the right moral explanation of why this is the case. Beliefs of people, why they do it, and whether they take the actions of others to be relevant is neither here nor there, right? And initially, I think in the examples there's an ambiguity about how Dworkin intends the distinction. But later in the text, Dworkin makes it very clear that he means the normative reading. He says, Hart is pointing to a case where the convergence of others helps to justify a duty and to assert a normative rule to that effect. So in the case of churchgoers, he says, look, there's a moral value there to show respect to people's expectations. You shouldn't offend the expectations of churchgoers by not removing your hat, because you have to show respect to what's happening. You attend a service, you have to be respectful to the occasion, and there is an expectation that you do so by removing your hat. So the moral value of respect or preventing offense makes the fact of convergence relevant and creates a duty for you to do so, right? The way he puts it is that convergence and attitudes helps justify a rule and a duty, right? These two go the same, right? So the locution is conventional morality practices are those where the actions of others help to justify duty for you. Actions and attitudes, okay? All normative, all moral. Now, if you fast forward later on to the literature about Hart's postscript, the question there by many of our colleagues seems to be, well, Hart would be right to be conventionalist if it is true empirically that judges take as the reason for applying a criterion of validity that other judges do the same. But that wasn't Dworkin's challenge. Dworkin's suggestion to Hart was, you would be right if it is the case that, morally speaking, the fact that other judges follow Parliament is a reason for you to do the same. That's the offer to Hart as a possibility. And Dworkin thought it's a viable possibility. Hart would be right. Okay, so just to recap, at that stage of the argument, according to my reading, Dworkin is saying to Hart, look, you could be right in terms of your theory if it is the case that a judge in Mexico City has a duty to act in a particular way, partly in virtue of the fact that other judges in Mexico City are following some common practice and have beliefs about it. Okay? This is the offer to Hart. This offer has nothing to do with the mental states of officials. Do you see? Whereas the reading by the positivists was that the offer of Dworkin to Hart was to do with the motivation of officials. That's neither here nor there. I think we spent 30 years talking about that, and there have been many articles discussing this, and I think that's a stray. Okay, now, the second part of my paper draws on a line in Modular Rules 2, in which Dworkin, it's the second part of the argument. So Dworkin says, okay, this is possible. There are cases where the practice of others justifies or helps justify your duty, but Hart gives the wrong explanation. Okay? And why is that explanation wrong? It's because of this. Dworkin says, on Hart's theory, the content of the obligation you have is the same as the attitudes and beliefs of the officials. That the normative rule they assert exhausts the duties people have in their practice. And the objection Dworkin made is that that's a mistake because within a practice, even though what others do may affect your duty may go beyond what they assert or below what they assert. It may go below because what they assert is morally wrong, problematic. It may go above because other principles may come in and qualify your duty. Other principles of morality may be relevant. Remember, conventional obligations is a subset of obligations, right? It doesn't exhaust morality. So his point is that, well, Hart, you get this morality wrong, because you limit it. You make the practice both a limit and a threshold. So that's the objection. And then in the last paragraph of that section, Dworkin says, the positivist may be right about the relevance of practices, but he has to make out his case in a different way. And that, reading back that article, struck me as a claim, because it assumed that at the time Dworkin thought what's essential to positivism is not the claim that the content of the obligation is exhausted by the practice. What is central is that the practice helps us justify the duty. So he says, the positivist may be right. Practice may help justify the duty, but not in the way Hart suggested. Okay? So, to me, that's striking for many reasons. First of all, because there's common ground, right? Both Hart and Dworkin thought that in law and many other practices, like the church, what others do affects our duties. And if you want to give us an account of what legal rights and duties we have to take into account the practice of others. Maybe not in the way Hart suggested, but he got that right at least. So it kind of leaves open the idea that both Hart and Dworkin were conventionalists. If by convention we mean this idea of it being relevant that people converge and have attitudes about it, then they agreed on that. So what you don't have, if you revisit the passage as I do, you don't have this friction between conventionalism being a positivist idea and conventionalism being a natural law idea or I know you don't like the phrase, but interpretive idea. But then when you move to so what I say in the paper is the aftertaste of the model of rules too is that the positives may be right. That's what I took away. And then you fast forward to Lord's Empire, and this possibility of the positives being right is not taken up, because Dworkin doesn't present conventionalism in a revised light, whereby what's central to it is that practice of others helps justify obligation, but not in the way Hart suggested. He defines conventionalism in a Hartian way, that the content of the obligation exhausts the duty. It's both a limit and a threshold. If you go to chapter 4, he defines conventionalism in a narrow way, not what could have been a revised way, a more friendly amendment to Hart's theory, whereby it's neither a floor nor a threshold. So what I'm saying is that if Dworkin had done things differently, he may have presented his own theory as a version of positivism, so to speak. Why is that relevant? Well, it might be a matter of terminology, because in the paper I say that for Dworkin himself, the practice of others helps justify his duties. His own theory was one in which past practice of officials matters for what rights and duties you have, and famously he argued that the content of those duties not to be equated with the beliefs and attitudes of officials, which may or may not track the correct moral reading of the past practice. So this, what I call the revised or the better reading of positivism, is the one he ends up accepting, albeit under the label of integrity. But that to me still matters because of two reasons. First of all, it drove friction between Dworkin and positivists for a long time. For decades, there was more focus on the differences between Hart and Dworkin, or positivism and Dworkin, than the similarities. I think there was polarization. That explains all these articles challenging Dworkin's offer to Hart about the motivations of officials. So it led to polarization. That's one thing. But the second thing that happened, in my view, is the following. Conventionalists of the positive kind forgot Dworkin's offer, that the offer is normative. Conventions matter because they are moralized, because of moral reasons. And positivists embarked on a project of arguing that conventions are central, but not for moral reasons. For reasons of coordination, for reasons of, law is a shared activity of joint planning, and none of this is to do with some moral justification for why officials are justified in so doing. And I think that's a mistake. I think that's a wrong turn in legal theory. If you see the truth of convention, I think Dimitris Kyritsis has done a superb job bringing the people on the table in the article he published in 2008, where he made the point that conventions cannot separate positivists and non-positivists, because they share the view that the practice of other actors in law matters. So what we have to explain is why it matters and how it matters. But if you are following the debate correctly, as I urge you to do, the difference is how it and why it matters in normative terms, not in an empirical sense. It's not social psychology, right? The idea that we have to go and interview judges. Why do you apply this law of parliament? Is it because you think that other judges do the same relevant to why you should apply it? That's not the process. That's irrelevant. It's neither here nor there why judges apply the law of parliament. What matters is whether it's relevant that you have this practice of people following parliament. When you are a judge and you have to decide a case, is it relevant that your colleagues do the same? Of course it's relevant, right? And I think what brought this to me home is what's happening in Europe at the moment. So in Europe at the moment, you have a supranational order, the European Union, which developed gradually through international treaties and through case law. Very little in the treaties governs the details of integration. So the European Court of Justice at the time had to develop doctrines about how European law interacts with domestic law. They did so by developing arguments. There were no rules in the treaties. They developed arguments that European Union law trumps domestic law, including constitutional law. And they develop arguments of moral argument, effectiveness, coordination, fairness, fair play. And we don't have rules of conflict in Europe about whose rules should be given precedence in the case of a conflict. What we have now is a case of a national judge have to look what's going on in other countries. Do other countries follow this directive? They do. Okay, that's relevant. Now, why does that matter? Is it fairness? Is it because we have to ensure a common market? Well, the only way you can ensure a common market is if every court applies the same criteria. Because you can't get benefits of a common market unless you have the same criteria for what is a product and what isn't. So there, the value of coordination, in a moralized sense, it's a good thing to have a common market, it's a good thing to have the benefits, explains why if you are a British judge, you have to look at what the other judges are doing in France or in Germany or in Brussels. And there are no rules you can follow because there is no text, right? To decide the case, you have to look at what other... Put differently, the practice of courts all over the European Union helps justify why, as a judge in Britain, have to do the X or Y. Okay? So there, the idea of conventionalism is at its best, where it's not about following rules, it's about assessing the relevance of the action of other judges and other legislatures or executive. And I don't think that you can find one single principle that can explain all the different reasons why judges have to look at what other people are doing. Even if you understand attempts by Jules Coleman or Andre Marmor or Scott Shapiro to link conventionalism to an idea, coordination or shared planning, and you understand this in a moralized way, it helps justify duties, you will only explain some legal duties, not all, because morality is diverse and law is diverse. There will be many moral principles telling a judge, look, you have to look at what other institutions are doing. Okay? So I don't think you can pinpoint to one big idea behind conventionalism, which is, in a way, the defect of that theory, the way I read it, because it's not grand, right? If, like other people, like Scott Shapiro or Andre Marmor, you say, law is about shared agency, law is about it, then it's more appealing. I think we are attracted to single ideas as lawyers and as philosophers, to point to one big idea behind an area of law or behind law itself. But if you think like Dworkin did, that law is a part of moral practice, and like Hart did, then it's unlikely that there will be one moral principle that defines everything, right? So the takeaway lesson from me is that there's truth in conventionalism, but we do better not to try to find one moral principle behind it. And we do well to do what Stephen says, argue a case. And in arguing a legal case, you will see, at the end of the argumentation, you will be pointing to the action of the legislature, of other judges, past and present, for why this person in front of you has the duty he claims or not. And I think Dworkin's insistence on integrity obscures this aspect. So that's why I think it's important to revisit the distinction between concurrent. If I have any complaint against Law's Empire, is that the way it's framed perhaps doesn't pay sufficient attention to the fact that the obligation of the judge and the rights and duties we have here in the room, the legal rights and duties, part of why you have them, the justification of why you have them, involves a complex account of the actions of other legal actors, legislatures, executive, and previous courts. Sometimes, and I know it's a caricature, but Dworkin's theory of integrity has the judge simply looking at facts and doing a moral job of going straight to morality without necessarily looking at institutional action. And I think that's an important aspect of law, and it may be essential to it from a point of view of Dworkin's theory. So I think I'll end here. I don't know if I went over time or...
that's perfect. We have 4 more minutes, so let me get the queue for the questions. I have Miguel, then Nico, Scott, and Nico, Scott, then...
Yeah, this seems to be on. So, thanks, George. I really enjoyed the paper. As you know, I'm quite receptive to the project. trying to find out what, if any, resources there are within the project of legal conventionalism to rethink some of the nuances of the heart-thought debate which you described at the beginning. I have, I think, 3 points to make, which in many ways mirror the structure of your discussion. To begin, let's start with the dialectic. And what you're proposing to do is to take heart as offering an interesting account of moral obligation, which could also illuminate legal obligation. Now, I think the source of confusion here, and something that you didn't sufficiently bring or talk about in the paper, was when we talk about a rule, or rather the notion of a rule, we seem to have two sorts of ideas in mind. What's tended to develop over the years is an actual specific metaphysical thesis about how rights and duties obtain, right? Rather than being a loose notion which we can use as a placeholder to discuss different ways about how it is that common practices generate a given standard. To put the point more specifically, I think the problem with Hart is, or at least there's enough in his text for you to read him in this way, is he has a specific problem regarding chains of validity in terms of who puts whom in charge to make sorts of decisions, and it presupposes a certain picture of how it is that legal rights and duties come into being, and they come into being simply by certain institutions communicating a characteristic intention to do so. Now, the relevance of all of this is because I think it bears in mind, it has an impact on what you have to say with respect to the relevance of motivational attitudes when it comes to explaining the project of legal conventionalism, and in turn your proposal as to how we needn't take that poison chalice, as it were. So moving on to point 2. Bearing the earlier point in mind about how you can read Hart in two different ways, there's the dispositional type of view, which you're concerned to take, which is the idea that the dispositions of certain actors and certain officials are constitutive of the standards which we're interested in explaining. The other view is that the rule is understood as on a line of a text which conveys or parlays a norm with explanatory directness, and therefore judges have to recognize that as a result. So that I think I won't get into the debate of which way it's better to read Hart. I think there's equal material in the text that could go in either discussion, but I think it does explain the route you were talking about with other positivists. But more interestingly for the purposes of your paper, I think it bears on why the compliance-dependent feature of judicial practice may be relevant. Okay, you're coming from the perspective that ultimately it doesn't really matter. Okay, but what really matters is that there's a common practice, and that judges engage in this practice with other legal actors, and that has normative significance. But is that sufficiently fine-grained enough? Right. So yes, they engage in a common practice, but even if you don't take the alternative empirical understanding of social convention, still there's a difference between a case where judges and other legal actors are engaging in that practice because other people are engaging within it, and they're engaging in that practice for other reasons. Now, that's not to take an empirical view of social conventions. It just means that there's two different ways in which the obligation could come into being. Okay, so the reason why I think that matters for your proposal is because it then may open up the space for a version of legal conventionalism moralized, as a moralized notion, but which nevertheless is distinct and competes with Dworkin's model of law as integrity, whereas for you, what it really is a way of putting Dworkin's point in a more effective way. So here's how I think we may draw the distinction between those two accounts based on this element of compliance-dependent reason. The distinctive feature for me of Dworkin's model, which many of us in the room share, is the idea that certain moral principles have a constitutive role to play in whether legal rights and duties obtain. You seem to be assuming that as a conventionalist, from a moralized perspective, we can accept that general claim. And in order, the way in which you're able to do that is by assuming that the compliance-dependent aspects of judges' motivations are not essentially relevant. But I wonder whether that's all too neat and a bit too quick, insofar as when we talk about a convention, the principles would have to be different, it seems to me. So the principles that Dworkin has in mind are, for example, those which are implicit or may underlie what they actually said and did, rather than what they actually have as a mentor of their propositional attitudes with respect to what they're doing. But surely if you wanted to be, when we talk about conventions elsewhere, right, outside of the law, that's not what we talk about. That's not how we have in mind why the convention binds and how it obtains. What we seem to have in mind when we talk about the rules of the road, or why people wear suits to weddings, or why people engage in common practices, the beauty of the account is that you manage to capture the fact that the practice features in the motivational states of the actors. But that's not possible on your view, okay? And this also is not just from a conceptual perspective, it also matters on the normative question of, say, integrity, okay? So, as Dworkin sees it, the point of subscribing to law is integrity, is that you don't have to be sidelined with positing instrumental things such as coordination and these other social goods which you might bring about. So, I know it's a bit long, so I'm still thinking through these myself. If I was to bring it to a concise point, I think we may do better to explore the possibility that a moralized account of the conventions, which by hypothesis are followed by judges and other officials, may provide a better account of what's going on at the conceptual level, insofar as we're able to actually capture the fact that the propositional attitudes of the legal actors are significant in why legal rights and duties obtain, and it may also do better at the moral level because it doesn't commit us to standards which are in no way featured in the agency of those whose task it is to create legal rights and duties. I'm not saying it's the better view, but it seems to me that it's a view suggested by what you said, and I would interested to know why you think we don't need to go down that road.
Right, thanks, Miguel. That's really really helpful. I'm just thinking through your points myself. So, let me take your first points first. So, in the concept of law, you have I'm here a student of Nikos, so you find this shift between
Chapter 7,
talking about rules in terms of the dispositions of practitioners to convert the convergence of behavior and the attitudes that this ought to be done. That's what a rule is. A rule is where you have those things. And remember what I highlighted in the introduction. He says you have to define what a rule is. That saying law is about rules doesn't get you anywhere, right? So you have this theory of what a rule is. And then, as Nikos has pointed out, then you go to chapter 4 and 5, and then rules are presented as text or formulations in a canonical form. No vehicles in the park, right?
Yeah.
And there the rule gets a different meaning. The rule is something that someone postulated, and it will be vague, because how can you predict what will happen in real life? So it will have gaps. And so there you have the second theory of rules, which is rules as text, right? And that's not compatible with the promise in the introduction that we cannot use rules in the generic sense because you have to define them. Saying that there are rules and equating rules with text is not really illuminating. It illuminates our understanding of law no further. I always, the first thing I tell students in the first year when we give introductory classes is, don't mistake the text for the law, right? You can burn all the texts there are of the law. You won't make the law go away, right? If you sneak into Parliament and you destroy all the official acts of an Act of Parliament copies, you wouldn't have thereby repealed all the law that's binding in England. So the text is not the law, right? And then you can have variations. It's the beliefs of the person the dispositions or beliefs of the person who enacted it, right? You can go down all these routes, but for Hart, the only theory we have in the book is the theory of social practice. That's the theory we should test. So going back to your last point, I take you to be suggesting the following, that it could be that for moral reasons, what matters is not just the actions of officials, but also their reason why they do it. That conventionalism is the view that it's not only relevant that all the judges in Mexico believe that Congress or Senate should be followed. It's also relevant that they believe that what other judges are doing justifies why they should follow Congress or Senate. So that's part of what the convention is. So if law is to be conventional, it should matter morally why judges do what they do. Now, my proposal, my suggestion is that it is true, Hart was right, attitudes may matter, but attitudes like expectations, for some reasons like offense, or coordination, or effectiveness. But what to me doesn't matter is whether the judge believes there's the same moral reason why you should follow Congress. So some people may believe it's because of democracy, or because you are afraid you will be fired as a judge, or because you feel peer pressure. You know, everybody, every judge follows the same idea. That's what I find irrelevant. And that's what I don't see any normative version of conventionalism.
No.
Making the motivation, not just any motivation, the motivation about why the judge has the duty he has.
Right, I should probably come in there. The point I was getting at is not that point precisely. I'm saying that what's distinctive about a convention, moralized or otherwise, is that it's to take the action of a particular group. Right? And it's that action of the group. So we're forming queues because other people are forming queues. We're wearing suits because people are wearing suits. So from a moralized perspective, when we want to tell the story that it's moral principles that explain why that is.
Yeah.
But so then you know the story. Then you get the deviant theory about what the convention requires.
We can fight. I think this is a discussion about what is a convention outside the law, and you can fight this conceptually and say, you know, unpack the concept. You know, would it be a convention if there is convergence, there are attitudes, but people don't actually converge because others do it? And maybe paying taxes is one example, right? So maybe on that definition, paying taxes is not conventional, whereas joining a queue is. But my answer to that is that only so far you can go by unpacking the concept. And the use of the concept is very loose. So there are philosophers who say it's perfectly meaningful to utter the following phrase: let's start a convention. None exists, but let's start one. Now that doesn't seem to be compatible with the idea that conventions, what's central about them is an already ongoing practice where people converge and take the fact of conventions as their reason.
No,
the idea there is let's decide to do something, right? And this I think is Margaret Gilbert, who says that this should be captured by our account of convention, that you can start one. Right? They start a convention of students ask questions first, right? So I don't think the concept of convention would get you very far. You would, at some point, I think, moralize it in the sense of why does it matter? Why do people actually believe that the fact that others converge is relevant? Well, because there's a moral reason. And then the descriptive element of the definition piggybacks on the normative. Like it's derivative of the fact that, they have those beliefs because they're trying to track a normative reason. And conventions point to the reason, not to the belief. Right? So the belief of X, a theory of a belief of X is not a theory of X. Right?
No, I'm not saying otherwise. What I'm saying is that there is a difference between engaging in the practice for compliance-dependent aspects of it, and that's morally significant. I'm not offering a descriptive account, but I'm saying that even from a moralized perspective, what a conventional obligation or how it comes about, because of the characteristic mental states involved, could be different from another practice-based obligation which is not conventional.
I agree.
But I'm not endorsing a conceptual account of conventions and saying that. I'm saying that even from a moralized perspective, we can be more fine-grained in what a conventional practice
I would be,
picks out.
another point. I would be inclined to define conventionalism as abstract as possible so that everybody's on the table. Because what you suggest to me is, I don't want to make it the case that conventionalism rules out some other way in which the actions of others plays a role. And then we have a competition between conventionalism and some other normative theories. No, I'm inclined to define it as abstract as possible, so not to beg the question against some other theory. I want to see all those theories as part of conventionalism.
So we have Nikos and then Scott.
So I have a number of points. The first two of them are smaller, but then I have some big picture thoughts. So the duality of the use of the notion of a rule in heart. So we have rules as patterned action and attitudes, and then we have rules as textual formulations. That happens, by the way, in chapter 7.
Sorry,
not before. So I think that there's no real tension there. It's just surprising that Hart, without prior announcement, starts talking about texts. He should have said more, but his thought is pretty clear what it is. It is that rules in law get made by communication of rules, by communication of standards. So rules, I'm sorry, duty is always explained in terms of rules, and rules, in general, are constituted by pattern, action, and attitudes. Now, the case of law is where we have a settled practice, pattern, action, and attitude, that constitutes a rule, the kernel of which is to recognize other actions as constituting rules, right? And the other action that recognizes, Hart is not explicit about it, we have to sort of, reverse engineer it from what he says from Chapter 7 onwards, is that others get rules made, they create rules just like that, without waiting for a practice to settle, by communicating the rules, by conveying standards. So there's no, I think, real tension. It's just that Hart has failed to explain why we should accept that that's the way, and indeed the only way, in which standards in law get made, get created. What should this be the only way in which the action of others is relevant in the domain of law? Now, that was the first minor point. The other minor point, at some point in your talk, you said that Dworkin sounds like he is talking about motivating reasons. And you mentioned his discussion of the fact that people don't take the fact that others do what they do as their reason for not lying. And I think that there's no ambiguity in what Dworkin is talking about in that piece. So Dworkin is trying to do two things in that paper. The first is to refute the theory in its substance, that is to say, to argue that is not a good explanation of the normative territory. He doesn't really get the normative facts right. Okay? And his second ambition is to also say that the theory, Hart's theory, doesn't really get the self-understanding of insiders right. In other words, he doesn't get the concept of duty right, because Hart told us that it's in the very idea of duty that that a duty exists just in case, when and because there is a settled practice with the right attitudes on top of it. So you can refute that claim, that part of Hart's claim, that his theory is a conceptual theory, it's an analysis of the concept of law, by showing that it doesn't really get the logic of certain statements right. So when I say there is a practice in my community, when I say that I have a duty not to lie, I don't mean to point to any settled practice of people not lying, right? When I say that there exists a duty not to eat meat or meat products, I'm not thereby pointing out to the fact that there is a settled practice of not using meat or meat products for food, right? So it doesn't get the logic of the statement right, and also it doesn't get the normative territory right. So
hold on,
separate things.
Why is that a challenge to Hart? Because on Hart's theory applies to both, right?
What do you mean both?
Concurrent and conventional. So
no. This is a completely separate issue. Hart's theory is that the statement that a duty exists, right? The standard, though unstated, background or context in which a statement that a duty exists assumes is the existence of a settled practice with a certain attitudes. This is Hart's conceptual claim that aims to tell us that this is the nature of duty, and it's also that is the nature of duty in virtue of the fact that this is what people imply when they say that a duty exists. So Dworkin in social rules and legal theory needs to do two things. He needs to show that Hart gets the logic of statements of duty wrong, and also, and independent of that he gets wrong what is really happening when a practice settles and affects what you owe to each other, what we owe to each other. So Dworkin says Hart gets the relevance of of settled practice wrong, and he also gets the inferential links that Hart thinks are built into statements of duty wrong. right? That's why he talks about what people mean to say or are thinking when they assert the duty not to lie, right? He's not really talking about motivations. Now, okay, these are the minor points. Now, the other thing, some more bigger points. To think that conventions matter is not to think that conventionalism is right. They're two different things, right? And I think in your effort to draw a big tent under which everybody can be accommodated, okay, it's an admirable ambition, but the problem is, the risk there is to flatten distinctions that are pretty important. So you mentioned in your response to Miguel a minute ago, and along the way when you were talking, that you talked interchangeably about the thesis that the action of others matters and the thesis that conventions matter. They're not the same thing. The action of others matters. So, the fact that, you are in, the fact that you jumped in the pool to save the drowning child matters to what I have to do. It's no longer urgent for me to jump into the pool to save the drowning child, given the background that you're a better swimmer than I am. So the actions of others have an impact on what I have to do. What you do has an impact on what I have to do. There's nothing to do with conventionalism. Sure. All right? So it's one thing.
It has to be narrower than that general claim.
I'm sorry?
It has to be more specific than that general claim. You're right. Yeah.
It's not.
I agree.
Conventionalism is not even the thesis. It's not certainly not the thesis that the action of others matters to the duty or to my duties. It's not even the thesis that social practices, set of practices matter to my duties. It's something else, and this is conventionalism in the sense that that Hart was a conventionalist is something else, completely different. It's orthogonal to all this discussion. It is a non-realist view about what the nature of duty, right? So Hart thinks that duty, in its nature, just is a set of practice, a kind of pattern, action, and attitude, a combination of pattern, action, and attitudes, right? It's a non-realist view. So, and along your talk, for instance, when you suggested that Dworkin should be more ecumenical and sort of might self-describe as a conventionalist, except with a different understanding of convention, and in that way he would bring the positivists into the fold, and they wouldn't fight so hard over those years. I mean, how do you fit Joseph Raz in there? Joseph Raz doesn't think, like Hart, that pattern, action, and attitude constitutes duty. He's a practical realist, and he has no time for conventions, really. Right? He's a positivist, and what makes him a positivist is not that judicial practice determines the content of the law. He doesn't think that, right? What makes a positivist is something else. He thinks that the law is a separate, standalone normative system, the existence of content of which can be explained without reference to any moral facts. That's what makes him a positivist. Conventionalism has nothing to do with it, right? There are conventions out there, Marmor and Shapiro and so on, and these guys are also positivists, but that doesn't mean that you're a positivist just in case you're a conventionalist or the other way around, right? So I think there are two things that are orthogonal to each other. And finally,
you are testing the limits of my memory.
Okay, I'm sorry. I thought you were taking notes. You want my notes?
I am, but...
So just a final thing is, just to go back to a point that I touched in passing, the way you presented dialectic at the beginning of your talk was slightly confusing to me about the role of rules. So the explanation of the notion of a rule is not where concept of law begins. It begins the explanation of duty. So duty assumes this background context, namely the existence of a practice, and practices generate rules, and so finally we say that duty is explained by the existence of the rules, which are in turn explained by the existence of a set of practices with attitudes. So his ambition is to explain duty in general, right? All duty. And then we explain legal duty as a special case where we add to the basic layer of social practice, we add to it. We are allowed to leverage that into a machine for producing duty on demand. But the basic explanation of duty always is, the basic explanation of how it is that there is a binding reason to do something, take some action, is the existence of some practice. All right.
Okay.
Finish here, I'm sorry.
Thank you, Nico. It will take me months, if not years, to do justice to your comments. But let me just try now on your first point. So your first point is this. So you say there is no real tension. I mean, this is something I attributed to conversations we've had. So you pointed out to me that there's this shift between rules.
Doesn't explain it.
Doesn't explain.
But it doesn't mean that there's a tension.
Okay, so okay, but to me, this spelling out is not really in the text. It's really imposed on the text. You think you can actually infer from the move. Let me put it another way. You are saying rules as text in law. The idea that text spit out duties, legal duties, is compatible with the theory of duty, the social practice theory of duties we have. Yeah, is compatible. Why is it compatible? Because that has contribution. He explains that ultimately it's the practice that justifies why these legal duties exist, but sometimes it goes via the text. Why? Because officials accept to treat the text of someone as a...
No, sorry. That's not what I meant. What I meant is that we have a certain practice, the common of which is that we recognize the actions of Parliament as duty generating, right? It's a rule of recognition.
Sure.
And then, how does Parliament generate duty?
By enacting...
without any argument, Hart says, by conveying standards.
Sure, okay. Fine, I have no quarrel with that. It's just not clear in the concept of law that that's what the theory is on the table. The theory is, in the early parts of the book, we have the social practice theory as the theory of generating obligation. And in chapter 7, where we are discussing vagueness and gaps, we are doing so because we got to those texts via the social rules theory. That's not explained. And I agree with you, it's compatible with, it's what the theory will get you if you apply it to text. So I have no quarrel with that. Your second minor point seems to me to be more major than you make it out. So you are saying to me you are being unfair to the reading, because what I do suggest in the paper is that Dworkin runs the two together. Dworkin fails to distinguish between normative and motivating reasons. And you are saying no, he's doing both, because he has to challenge not only the view that the convergence of behavior of others is normatively relevant, but also the view that the way we understand how practice, that's what I mean. Now there I'm a bit puzzled, to be honest, because the way Dworkin presents the argument is that Hart's theory applies to both in terms of it generates obligations in both cases. And let me just finish. So Dworkin there doesn't take part of Hart's thesis to be that the logic of social rules theory implies this self-understanding. So he doesn't think that it's part of Hart's thesis that people converge because others are converging. So why would he be minded to challenge that?
Right here. There's nothing to do about the logic of the social rules thesis. Here's how it goes. Hart says that the logic of statements of duty, right, is.
I don't see that in the concept of logical. He doesn't say that. He doesn't talk about logic. He doesn't talk about.
Okay, let me repeat in almost verbatim what I said before. The passage that I cited.
Repeat what Hart said.
Yeah, that's what Hart. That's what I'm saying. It's an also almost verbatim quotation from Hart, concept of law. He says, the existence of a social practice is the often unstated background or context of statements of duty. Okay?
Right.
That's what makes us believe, says Hart, to make us accept that that's what it is for a duty to exist.
Look,
so when I say there's a duty to phi, I implicitly, right, presuppose, and if you understand what I say correctly, you also infer that from my saying, that there is some social practice.
You make it out now as if Hart is doing two things in the concept of law. No, one is explaining obligation, and then the other thing is explaining the logic of claims of duty.
Obligation by explaining the logic.
No, but if you explain the logic of how people talk, that's not explaining obligation. You explain how people think it explains obligation.
Well, try telling that apart.
But let me just say something else, if you allow me. So I'm not the one responsible for the misreading, right? So you have all these people reading the exchange saying that the offer to Hart on the part of Dworkin was to do with why in fact judges follow the same criteria as others, right? And therefore that misreading, I think is a misreading. Even if you're right about these two things he was doing, Dworkin, one, take on Hart on the normative side of things, B, take on Hart on the self-understanding of the logic, that still wouldn't provide the basis for reading the exchange the way it was read subsequently as an alleged disagreement about why judges do what they do, which would turn on the empirical facts. Let's interview judges. Why do you follow Parliament, right? And I think the distinction between motivating reasons and normative reasons helps to clarify this point to those people and tell them, look, right. Okay. To me, that's a very important part of the paper, right? So I think your point is, to me, you are being harsh on Dworkin's. Or I can. No, but then I want to come to the even stronger challenge in your point. I'll finish there. The third point about what is conventional. So you are saying rightly, I think, it can't be the case that someone is a conventionalist when he or she claims that the actions of others help justify your duty. You're right. You step in front of my car, you change my reason, I have to stop. Right? Sure. Yeah. So it has to be way more qualified. So the way I would qualify this is, first of all, it's about not just the actions, but the attitudes. Second, it's not just about the action of anybody, it's about the actions of institutions, of political institutions, legislature, executive, and judiciary. So that's more narrow. And second, it's about a practice where there is a degree of convergence. So that makes it even more narrow, because in law, for example, and in queuing, you have people doing the same thing, taking the same action. So it's not just one person changing the actions of the reasons of others single-handedly. It's a lot of people doing the same, and not just a lot of people. Let me finish. Not just a lot of people, institutions, legal institutions. So I believe I can give a more narrow definition of why law is about conventionalism in a normative sense, which would bring everybody on the table. I agree with you, saying in general it's about the actions and past practices of others. I wouldn't do it. That wouldn't make everything conventionalist. But the way I narrow it down, I think will get us far enough.
Thank you. Scott, then I have the person in the middle, then Dimitris, and Sager.
I will be quick. I just want to follow up on Nikos' second point, because I think you're right to see a more significant challenge there to the presentation, maybe not to the ultimate claim of your paper, but to the way you've presented the argument. So page 58, I found a copy on Google Books, of taking rights seriously, the model of rules 2. Yeah. So Dworkin's discussing the example he's constantly using about the churchgoers and the male babies and bonnets, and he says, it's true that they'll frame their dispute even in this trivial case as a dispute over what the rule about hats in church requires. But the reference is not to the rule that is constituted by common behavior, that is a social rule, but the rule that is justified by common behavior, that is a normative rule. They dispute precisely about what that rule is. And I think there's a moment here where Dworkin's objection to Hart does rest on a sociological claim. He says, right up front, judges are in the position of the churchgoers. He actually thinks that Hart agrees about that. They're not in the position of a sociologist looking at it. They're participants in the practice. But he has a disagreement about Hart with what judges are appealing to, right, or what churchgoers are appealing to when they assert that there's a duty. And so it seems to me that there is, there's something else going on too, and I think you very well highlighted what it is, right? He thinks that that Hart is mistaken two things. He's mistaken what it is that judges or churchgoers are appealing to, and he's mistaken how it is that conventional morality works. But it's really important to him, I think, to make both points. And I just think you want to construct the presentation in a way that makes clear that there's a point worth making there on the motivating side and not just on the normative side.
And thanks, Scott. That's very helpful. It is not worth making, hammering the point as well, though, that the degree to which the actions and beliefs of other legal actors matters doesn't turn on their motivating reasons, and doesn't turn on the sociological claim, right? Because often, again, I'm trying to set straight the subsequent debate, not Dworkin. Right? And then what you call the sociological claim is something that many people do. So it would be open. Some people think it's the following possibility is open. Let's check the facts. Is the law the kind of practice where people actually appeal as their reason to what other people are doing or not? And if it turns out it's not, if it turns out that every judge applies the criterion of validity he applies because he thinks that democracy is a value, or from different reasons, but not the fact that others are doing it. Would that tell us the truth about law? And I think no, it wouldn't, because whether or not law is the kind of practice in which the action of others matters doesn't depend on whether people think it does. And so this is the strong claim I'm making. Now, it turns out that typically, in cases like law, judges would think what other people are doing is relevant, what Parliament does is relevant. But morally speaking, from a moral point of view, it could have been different. It could have been the case that the motivating reasons are not, and vice versa. So the motivation doesn't really settle the normative point. And the normative point that's at stake, not the motivating point, right? So that's, hence the sociological point is relevant. Let me put it another way. So it's not just the positivists who think that. So some people think whether disagreement exists in law is important. So Dworkin makes disagreement a big issue. He thinks it suggests something about law, which is that it points to a value, because if we know the facts, how can we be disagreeing about the facts, or how to disagree about some value? So there's mileage to the idea of disagreement. And then some people say, oh, okay, that argument depends on whether there's actual disagreement, so let's go and see how much disagreement there is. And my answer to that is no, that's like a device, a heuristic device. Like whether judges can disagree about law, it's not what makes law what it is, it's just an indication of what might, and then you need an argument. You need a moral argument about why there's a moral value governing law. So when Dworkin keeps appealing to these empirical facts, right, to me it's just heuristic. And the argument is not empirical, the argument is not normative. Okay, let's take these empirical facts and then see why they exist. They may or may not be relevant, morally speaking, right? So
I think he's left open two avenues of response. One is Dworkin is, like everybody else, offering an interpretation of the practice, and so positivists might have come back and said, you just got the practice wrong. When you say judges are appealing to the normative rule, we can show you no. Actually, the reference they're making is to the social rule. That's one way they could have replied, and it's the way a lot of people tried to reply. Then there's the second thing, which I think you're totally right. It's the paragraph that comes right after the passage I read, where Dworkin offers them a different way of thinking about it. You could agree with me that they're appealing to the normative rule, and there's this different sense in which you think in which the practice might still be conventional. When he says the positivists might be right, they might be right, this is a conventional practice understood in a better way of understanding what conventional morality is. And I think that is the key inside of your paper and is totally worth making, but you don't want to pretend, I think, that the other argument isn't there, and that it's not important ultimately to his claim, because he wants to say, I've got this practice right, Hart. I'm explaining how people in it are behaving, and you're not.
I think, Scott, you just convinced me to take up your suggestion last night to retitle the paper, The Positives May Be Right.
Good.
Thank you. ¿Se escucha? Sí, se escucha. Thank you. Welcome to Mexico.
Thank you.
It's a pleasure. Well, I want to share with you a comment and two questions, no more. Around 1986, the year when I was born, Bernard Goldsmith...
Can you repeat again the date? 1986.
1986, yeah. The year when I was born, a philosopher, a German legal philosopher called Bernard Goldsmith, in a book called Justice Science, or Decalogy, he told some interesting things about the justice, and I want to share a comment about. He said, "Perfect justice is a matter of God. Only this type of justice will appear in the judgment day, when God will give us all the good and evil in the world. Imperfect justice is a matter of mankind, or human justice is about to natural practice of the reason of humans." I'm agree with that concept. I don't know. I'm agree with that. He said also that the right way to put in order a unity of values is through the argumentative theory and also with a fragment method of justice. Not like God's justice. Here in Mexico of 2014, the traditional perspective of our practice put in the center of the discussion the concept of system as the only source to build the topics, even the moral topics. Theories like Dworkin's are called irrationalist argumentative theories because we don't have a formal way to make the decision from the legal system, and the judge's decision by itself is the only back and guarantee of the reason which changed the reality. End of the comment.
So, what is the source of that?
About the concept of the imperfect justice and the argumentative theory.
No, the last thing you read out is by who? Oh, okay.
Werner Goldschmidt.
Okay.
Okay.
Todo fue de Goldschmidt. Toda la cita fue de Goldschmidt.
Sí. And the questions are, what do you think about this vision? Our legal tradition, I mean the civil law, is responsible of this? Or maybe our careless about the morality knowledge?
Right. Thank you very much for your question, which I would think is rather hard to answer. I'm not familiar with the work of this scholar. It sounds, what you read out sounds in spirit close to what Dworkin was arguing for. But I want to say something about the idea of reason and justice and the way it plays out in law. So there are traditions out there where you would contrast morality and law, right? So people would say morality is what you debate about. People disagree, have different views. You cannot demonstrate who's right. There are wars happening. People's morality is a religion often. The views come from the religious views or holy texts. But that cannot be a basis for running a society, because in a society you have to have rules and you have to have determination of disputes and you have to have enforcement. And so what law does is an instrument to bypass these disagreements and this. And that's why positivism gets off the ground, because it explains to you that law is about these postulated norms and systems, and right? And it's very common to contrast. I mean, the old debate between natural and positivism contrast law as a non-moral kind of way to settle disputes and morality. Now, I think we've come a long way since that, because now positivists of the kind we debate are not skeptics about morality, right? They have their own views about reason. They think there are reasons to do things and not to do things. So now you will be hard-pressed to find skeptics. The disagreement now between Dworkin and others doesn't turn necessarily on whether you think the right reasons, okay? So now we are at the stage where many of us agree that there are reasons not to steal, not to murder, blah, blah. And then we come to the law, and then we might disagree about how the law comes into these institutional ways of addressing those reasons, right? And you mentioned the civil law and the common law. I come from a civil law country, right? So I'm familiar with the civil law system. And when I first went to the UK, which is a common law country, I thought there was like a contrast between the two, because in the common law, the judge has, if you like, more liberty to develop arguments and resolve the case, whereas in the civil law, we follow a code, which is very detailed, and it's, if you like, accumulated wisdom. You know, you have the wisdom of centuries dealing with the same issues, right? But I think that's a superficial difference because of two things. First of all, if you know, I'm sure in Mexico is the same as my home country in Greece. When you study contract law or law of obligations or tort, you will do so via principles. You will explain, not just you won't just go to rules about deadlines and procedures, and you will also talk about principles. And these are the same materials the common law judge uses to resolve the case. And, you know, as far as I can remember my life as a law student, I got way more out of when the professor was talking about the principles than when we were going through detailed rules about deadlines. And so the life of the law is the life of the reason, right? The life of the law is the life of the principles and the arguments. That necessarily doesn't divide positivism and non-positivism nowadays. So I agree with your comment that the law of the life, you know, it's about reason and about justice. And I also agree that it's about argument, right? What we don't have yet have is how law comes into our general judgment about what the right thing to do is. Like, we're trying to also explain, I think Dworkin was trying to explain, there's a special kind of justice limited to law, right? So it's all good and nice to say, oh, law is about justice, but then that's not specific enough, to use Miguel's phrase, fine-grained enough, to tell us what kind of justice that is. And Dworkin himself did this hard work. He said, oh, it's about one value, integrity. I'm not sure whether Goldsmith, it's Goldsmith?
Goldsmith.
Where he talks about integrity. But that was the hard work Dworkin did. He says, well, there's general justice, there's justice absent a history, there's justice between friends and justice between family members, justice between colleagues in the university, and the justice in the law. Right? And this is the justice we have to explain. Yeah. Right? So, yeah, I mean, maybe nowadays it would be trivially true, law is about justice, but then we have to do the hard work of explaining what that means.
Thank you.
I have Dimitris and then Sager.
So, in your last answer, you said that we've come a long way because now positivists tend not to be skeptics. But I think Hart might have been a moral skeptic of sorts, and I wonder whether that has an impact on the argument of the paper.
You don't think he gave a theory of obligation? Of moral obligation?
He was not a moral skeptic.
He was not. He was a skeptic about moral realism.
Okay, that's different.
Moral
that's
realism
different.
was wrong.
Yeah. But moral realism is a meta-ethical view about.
Sure. That's why I said skeptic of sorts.
Okay.
So, and here's why. As you know, I share the ambition of co-opting conventionalist themes into the project of interpretatism. But I wondered to what extent we can also co-opt the argument of a model of rules too into that project. Now, you say that you draw this very helpful distinction between motivating and normative reasons, and then you say, well, the best way to understand Dworkin's use of reasons in Model of Rules 2 is the normative reading. I wasn't clear why you thought the motivating reading was not a good enough reading of what he was up to in Model of Rules 2. And one reason why it might be the proper reading is because that was the reading Hart had. So it may be that because part of what the Model of Rules 2 does is not just to offer a lifeline, but to criticize Hart, if it turns out that Hart was committed to the motivating reasons reading, then that explains why that could offer an explanation why Dworkin would adopt that reading in his criticism of Hart.
This sounds a lot like Nikos' second question. And what do I want to say here? What you put forward doesn't, I think, match the text, because Dworkin says there Hart's theory applied to both concurrent and conventional, and it shouldn't apply to both. So you're saying, oh no, Hart's theory only applies to one, which is where the motivating reasons exist. But that wasn't Dworkin's reading. Dworkin's reading is Hart tells us that duties arise when there's convergence and attitude of acceptance. But attitude is simply just the attitude of, you ought to do this, you ought to take the action, remove your hat. It's not the attitude of, oh, and I'm removing it because other people are removing it. That's not part of the theory. Right? So what you are proposing is not, I think, neither in the concept of law nor in Dworkin's reading of it, textually. So that would be my sense. I mean, you may think that that's what Hart should have said or Dworkin should have said, but that's not what they said.
Okay. So then what the critical part, the negative part of the claim in Model of Rules 2 amounts to is that what people do and say as part of their practice does not set either the threshold or the limit. So in which case the disagreement between Hart and Dworkin is that the attitudes that people have as part of the common practice that cannot give us the content of the law. But we've left behind the view that there might be an anti-realist reading of legal normativity, whereby when people have certain attitudes and these attitudes converge, then that gives rise to a rule. We've left that reading behind, or haven't we? In Model of Rules 2. So
yeah, I think the dialectic is, if you like, that Hart was wrong in giving an account of the obligation that exists in those practices. He was right that the practice of other had justified the duty and the rule, but not for the reasons, but not right to identify the content with the attitudes. That's that's why he moves on to say it's still possible for conventionalism to be true and the positivists to be right. So, okay, another way to put it. My reading of it is, Dworkin doesn't think that equating the legal duty with the practice or the beliefs of the practitioners is essential to positivism or conventionalism. Like that's the aftertaste of my reading, that you can be a conventionalist and you can be a positivist by thinking that the convergence and attitudes matter, but not that the duty is the same as what practitioners accept or believe. So that's the possibility left open, and then that's why I thought this should be tested in Law's Empire as an option, and it's not. It's the one he endorses, but not as a conventionalist theory.
Professor Sager.
I think we're late enough, and we're going to be taking these things about half an hour.
Okay. Then I have Eamon, and that's the last question.
Thank you. I'm also not very convinced on the move to legal conventionalism and bringing everyone in. We are all conventionalists now and so on. So let me just quickly point why. In starting your paper, you quote Dworkin, or you refer to Dworkin, saying something like, people believe moral obligations exist and do so plausibly even in the absence of a social practice to that effect. So morality does not have to be practiced to be obligatory. And this is pretty much around the model of Rule 1, I think, or 2 or something. And then in page 402 of the Hedgehog, and just before when he makes this autobiographic thing of the model of rules 1 and the model of rules 2, he says, well, first he denies the conventionalisms. He's against conventionalism still here. And then he says, interpretivism, on the other hand, denies that law and morals are wholly independent systems. It argues that law includes not only the specific rules enacted in accordance with the community's accepted practices, but also the principles that provide the best moral justification for those enacted rules. The law then also includes the rules that follow from the justifying principles, even though, and that's the part I would like to stress, even though those further rules were never enacted. So let me try to point to one example. When I was discussing this with Anna before. So not so long ago, in classrooms everywhere in the world, it was allowed to smoke in the classroom.
I remember those days.
Sorry?
I remember those days.
Okay. So you look younger than that. So the thing is that now we have rules saying something like you are not supposed to smoke in the classroom. And I think that might have some hint to you, like, oh, that's a convention now. We have the convention, and fits my moral thing of the right thing is not to smoke because we'll be damaging everyone else's health and so on. But the part of Dworkin is that that was the right answer, even if we didn't enact that rule. So it doesn't depend on the convention. It's because it was the right thing all the way was never to smoke in the classrooms. And so the justifying principle it does not depend on the convention on making this rule now the rule nowadays. And I was thinking of the sample also, and just I would like to point that to the thing of having don't bring the coffee into the room.
Which I was told not to, and I didn't, but I can see some people.
So, but let me say something. So there's one guy sitting next to you with a cup with a tap.
And in fact,
it's empty. It doesn't have any liquid.
Well, it's empty now. After 3 hours.
Let me say something.
And a big one at that.
Yeah. Let me say something else. Mine was filled outside. I drank it outside, and I bring the cup empty, just to keep the cup for the next time I have to go to drink. But that's why this is inside here. But there were still people bringing the coffee inside, and I'm not going to argue against that. What I'm going to say is that, which is the underlying principle of why we are not supposed to bring the coffee. And Nico's brought a very nice espresso inside, so I'm not. It's not a matter against Nico, because I completely see that for the discussion going, caffeine is helpful. So we are getting it wrong, that the reason is not to bring the drinks.
But look, I see the challenge perfectly, and here's my response. So, other things being equal, so absent what happened this morning, there's a right answer as to whether it's a good idea to have coffee allowed in the room, right? So, morality there will be telling us what the right thing is, independently of what people are doing, right? So, other things being equal, suppose that the best norm to have is not to have coffee in the room, cups. But now I turn up. I'm told not to enter with a cup of coffee, which is what I did. And I look around me, and most of you have a cup of coffee. And then I go, well, hold on a minute. That changes now my moral profile, because now I think it would be unfair if I'm the only one in the room without a cup of coffee. So morality now has changed, making it justified for me to go and get one. Why? Partly because you brought one in. So it proves my point that the actions of others matters. It can change your moral reasons. I think it would be unfair if I'm the only one with a cup of coffee, and that is because you brought one in. You don't think it changed my reasons for getting one now? Yeah. You don't think it changed my reasons? So previously,
I think you were right all the way down. It didn't change yours.
No, I'm now. But my point is, I hope you agree with me. If everybody else has one, I'm now permitted to get one for myself. And that's because you all of you flouted the rule.
But can I add there something? Sure. You've got to see this in the context of a certain degree of morality. I mean, if I brought in my black friend, and then saw that everybody else here were white, the fact that other people are refraining, I know they're refraining from bringing in their black friends, it has no bearing on what I have, it's right for me to do or not. None at all. Oh, I'm sorry. I just want to change the example a bit because coffee's rather neutral. But, there's a right answer. You shouldn't bring it into such a nice lecture theatre as this. But bringing in a black friend, for example, and then realising that no one else in the room is bringing in their black friend because black students aren't allowed in the room, changes it dramatically. It shows that actually the way other people behave doesn't have that strong effect on the way that you do. I mean, my view is... And I agree with that. I don't mean to deny that routinely reasons don't depend on what others do. My point is that sometimes it does, and sometimes it doesn't. And when it comes to law, it turns out that it does so systematically, in the following sense, that what past courts and legislatures have done is relevant to what legal rights and duties you have. So that's Nazi legal system? Not there. No, not there. You see, right. So, but even in the Nazi legal system, it would be relevant what kind of contract law they had. It wouldn't be relevant to exclude people from the contract law rules, but what kind of contract rules they practice would be relevant. What kind of land law they have would be relevant. So that's. So I'm just saying there's not that much weight you can place upon convention. Or you place weight upon convention when you ought to place weight upon convention. Sorry, I didn't want the final word. I'm mindful of being over time, so... Yeah. Okay, sure. I'm still concerned about what part of the work and you believe when. What happened to the chain novel? I mean, was that just a terrible mistake? That's a pretty extraordinary systematic pressure of past events on present evaluations, and I'm just curious whether, and partially about your views and partially about your views about Dworkin, what happened to that, to the chain novel? It's gone in a view that convention doesn't matter all that much. I don't know. I mean, we're back to my paper and over time. And probably we'll come up to these things after. The short answer is, it's going to depend upon what aspects of the previous chapters in the chain novel are significant or not. And it seems to me that's driven by evaluation. I mean, it's no more that I'm saying. But the fact that something is there is not conclusive. It doesn't settle the question of what is the correct way to write the next chapter. So it works for artistic evaluation as well as moral evaluation. Sorry, I don't think that's fine. That's fine. Please join me in a round of applause to George.